Meeting at 6:34 approximately. First order of business, accept a motion to waive the reading of the remote or virtual meeting.
Also move.
Second.
Any discussion?
Second.
In favor, roll call.
Dick Williams, aye.
Jim Norwald, aye.
Sean Moore, aye.
Aye.
And Norm Anderson.
Yeah, aye. If I may, Norm, when you do roll call, so we're not all speaking at once, can you call us out?
Okay. If I can remember everybody's name.
Or give us a number.
Yeah, right.
Maybe hey you.
Yeah, right. Okay. I guess we have quite a number of items on our agenda, and most particularly, we do have at least a member of the Concom here. They have met and taken a look at the conservation restriction for Maple Hill Estates. So I'm going to ask, unless anybody has any objection, to take our agenda out of order and go directly to item number 6. Is there any objection?
I'm okay with that. Nope. Who is from Concom?
Peter Crane. And I don't know.
All right. I definitely object then.
Okay. And I guess,
All right.
number one, this is our first look at this conservation restriction. We have not studied it or done anything with it. At least according to Dave, this is structured basically according to the state requirements, which is what we are requiring of a conservation restriction. I don't know how detailed the requirements for the state are, to be perfectly honest with you. And also, I believe we have not sent this out for legal review, which I'm assuming we will do.
Okay.
And I'm also getting a free jersey.
Mute.
The only thing
Okay. Yeah, I agree, Norm. I think that to go to town council, you're saying?
Well, yeah. However, in the meantime, I think our first thing would be to listen to and if we can, maybe address the
Yep.
concerns the Concom has about it.
Okay.
So I'm going to let you, Peter, lead the way on it.
Thank you very much, Mr. Chair. I'm Peter Crane, Chair of the Conservation Commission. I see no other members tonight, which is too bad. We'd hoped to have more here. But we did get those of you at the select board meeting get to hear it all again. We received the conservation restriction paperwork. We looked at it very briefly and noted two important things that we noticed that are, one, there's a self-conflict within the document. One side that says you can do no tree cutting, and another one and a different section says forestry is allowed. I'm not saying which one is right. I'm saying that it is within itself self-conflicting, and that's not good. The other thing is that there is no oversight, basically, no informing the Conservation Commission, who are the conservators of the land under the CR. No review, no information ever has to get passed to us, and so we think that has a chance to be problematic. We were wondering if this body is interested in participating in the discussions that we have about how to change the CR. And I know from a process point of view, at the end of the day, we have signatures from Concom, signatures from the Select Board, and then it goes off to the state for approval. That's a process flow. I don't want to exclude anyone who's interested in being involved in that discussion. Mr. Williams, you noted yesterday that you're the one who suggested the addition of the forestry. Let's have a good discussion about that to figure out the right way forward for the land. We're not interested in being tyrants thou shalt do nothing on the land. We're more interested in making sure that it has a good use for the town first and for the landowner second. That's really my spiel on this tonight.
So, and that was the only issue was the forestry part of it?
I can't say that's the only one. I have
Okay.
not, I've only quickly scanned it myself.
Okay.
And we are meeting next Tuesday
Next
night
Tuesday, okay.
when we plan to begin to go to doing a full review of the
Okay.
document. Now, we actually have the benefit of having someone on the Conservation Commission who has done a couple CRs in the last year. She's a conservation agent for another town,
Okay.
which makes her very well suited to use by this town. And we thank her for her time and her knowledge and abilities and everything she's going to bring to help us get this in good shape.
Okay.
Peter, after you guys, or the chair, when you guys are done with your review and, or the group, whoever's done with
Yes.
it, is the intent then to take that marked up document and send it to town council to make sure that we're good to go?
Absolutely,
Thank you.
yes. I would not,
That's all.
this is a legal document. I wouldn't ever pass it through.
That's all I
without-
was-
every legal document has to go through town council.
Okay,
As,
good.
as a matter of policy.
Okay, I'm fine. I just wanted to make sure. That's it.
So Norm, if they put it through town council, do we have to?
No,
No,
no.
but the town council's review has got to be after everybody's done with it.
Yes, that's
Yes,
what I was
I
getting
think
at.
that makes all the sense.
Yeah, okay.
And I would maintain that Conservation Commission would take the lead on that process. We'll get whatever feedback from anyone who has any. We'll integrate the changes that we know need to be put in. I'll run it past the select board. Holy cow, look at the rain. I'll run it past the select board, expecting no feedback from them. No, with no offense to them intended, it's just not their domain of knowledge. But since they're going to have to sign it, and then we'll ship it off to legal. When we get it back, everybody signs, and Mr. Blair can move forward with this project.
Go ahead, Dick.
Norm, that still has a special permit on our behalf, does it not?
Well, we still have the special permit. The special permit requires the CR.
Yeah,
However, we don't sign off on the CR.
okay.
Correct. But does that special permit, Norm, get executed? It's not official until the CR is finalized. Is that correct?
The conditions of the permit can't be met until the CR is accepted by the
Yeah,
state.
it's a condition, but I don't think we have I don't think we have a date certain for supplying this conservation restriction.
I don't have the decision in front of me. I'm not sure if there's a condition for time that says it must be enacted prior to the first occupancy of a house or what have you.
Yeah, I don't believe
But it
it.
doesn't stop the building construction and the site preparation that's currently happening on site. This process will happen in parallel with the building
I'm
construction.
fine with that.
Now, is the applicant aware of this development so that he knows that there's a
Yes, I've informed him that
process that-
I had a face-to-face conversation with him, telling him that we saw some issues that we want to work through, and he was amenable to getting the right work done. So we also don't intend to dilly-dally. We're not going to take 3 meetings to go over this and figure it out, because it is a fairly standard document.
Right. Maybe I'm putting the cart before the horse here.
Mhm.
But looking at this one thing that you have cited, which is section A4, cutting, removing, or otherwise destroying trees, grasses, or other vegetation prohibited. And
Somewhere in the specifically allowed uses.
B8, forestry and cutting.
Yep.
You say they're contradictory. I think with a minor change that they wouldn't necessarily be.
Oh, I agree that it's very possible we could make them compatible.
In other words, for example, on that number 4, cutting, removing, or otherwise destroying trees, grass, or other vegetation, other than as prescribed in section be 8.
Sure. Sure.
And to me,
If I may, gentlemen,
Yeah, go ahead, Sean.
can you hear me?
yeah,
Yeah, I don't know if you guys are speaking into table mics, but I can hardly hear you.
Wow. I don't think anyone's ever said
Okay.
that to me before.
Marilyn.
How about now?
Sorry.
Can you hear me, Sean?
Is this any better?
A little. No, not really. I don't think it's me. Marilyn, can someone else say something?
I can hear everybody okay, Sean?
Yeah, I hear you okay, Tamika. Weird. I'm going to log off and try to log back in. So excuse me.
It's turned all the way up. It wasn't?
No.
Well, yours may be one that doesn't need it.
Well, he's logging. The other point that just glancing this over and remembering, you had a good point, Peter. I don't see anywhere in this document of how this is administered. That's a good word. So if the state doesn't require it, is there an underlying, what's the word I'm looking for, underlying way to do that?
is there anything in Conservation Commission law?
Yeah, that's what I was getting. Thanks, Norm. That's exactly what I was trying to
And the fast answer is I don't think so because the Conservation Commission does not own this land in the end.
It's the homeowner owns it.
The homeowner owns the land. It's his property.
Correct.
So,
Is it the DEP then that has to?
no,
No,
No.
Yeah,
No,
but somebody
there's-
has to administer this
some-
conservation restriction, otherwise I could tear that.
adhere to it, to check on it.
Yeah.
You know. Does the Concom have a yearly review of all CRs in town?
to my knowledge, there has been a never yearly review of CRs in town. I mean, this is pointing out things that we should probably be taking on because we should be looking at.
Yes.
This actually goes, by the way, along with my question of what are all the properties in town and what are the attributes of those so we can, so that the town can take appropriate action with them. I mean, it's kind of linked with that.
That was your question last night. Can
Off
I get
of
a
our-
list?
Off of Irish Lane, there is a 7-acre over there that is still owned. The town would not accept it. They don't pay the taxes on there. That was Elbag and Susie way back when. And so heaven only knows where it is right now. Or did somebody build a house on it? And you don't know about it.
Yeah,
I mean,
okay.
that's why I'm saying, I agree.
Mhm.
Somebody needs to have a
List.
visual, a list and a visual inspection
Mhm.
yearly or thereabouts, something like that, semi-annual.
So, okay, so I guess what you
Okay,
basically,
so the planning board.
What's that, Sean?
Well, where does this leave us with planning board on this property?
Well, planning board is going to have. I'm sorry, I'm going to have to mute you, Sean. I'm hearing myself in echo. The planning board is going to have as much involvement with the conservation restriction as it would like to have. The planning board, after everything is said and done, the planning board has effectively no further involvement.
That's correct.
right,
Is that
Ultimately, it's the Conservation Commission and the Select Board that sign off on this document and send it to the state.
Correct.
Okay, that's what I thought.
All right.
assignment.
So should we, Norm, post a meeting for Tuesday of next week for a joint meeting?
Or should we allow them to have their meeting and then? I have a funny feeling.
we can do it several ways. If you would like to be there, we would welcome anyone who wants to come and discuss it. If you want to send email to Tamika, who is our administrator, as Concom's administrator as well, so that she can distribute them to the entire commission, and we can again have a roundtable that way. In person and electronic are really the two ways to carry this out.
Yeah.
If planning board believes that you will have a quorum at the meeting, please feel free to post. Just like we posted for tonight, although we have no quorum.
Yeah. So far I've heard two things. I've heard the tree cutting, the forestry. You seem to think that's able to be worked out.
I expect
probably pretty simply.
Probably.
Okay. Now the other item I believe is your concern with administration / enforcement.
Well, oversight is a word I'd like to use for it, or at least review.
Mm-hmm. Do you have any thoughts on that?
It is a standard part of the restrictions that our member has worked on. So we're going to have sample wording at that meeting.
Okay.
Good.
So you basically have suggestion ready.
Yes, and in fact, I'd be interested to read any of her examples, just because I'd like to see what they've done and has made it through the state that we could take and add to ours.
Okay.
Great.
I like that.
Yeah, I don't plan to go in and write. It doesn't make sense for non-lawyers to try to write a CR from scratch.
Mm-hmm. Yeah. I don't know that just sounds to me like it will be definitely a way of making this CR better.
Mm-hmm.
Yeah, because Peter, on 3, the legal remedies, that's the only place where it's talked about, where they enforcement of the terms as conservation restriction shall be at the discretion of the grantee.
Mm-hmm.
That's it, but it doesn't say how, what, when, or how.
That's right.
So if she's got wording, that'd be great. All right, good enough.
So I don't need a motion. We will have an agenda item for next Tuesday's Concom that will talk about this. If you are welcome, and in fact, Tamika, do we have any other hearings on Tuesday?
Yes, we do. We have 2 NOIs, and one of them is the continuation of Finn Park Road.
Right. Oh, that's going to stink. Excuse me. That's going to take more time.
But here's the thing, Peter, we stopped assigning times to when the hearings are going to take place. So does that give you some flexibility?
We certainly have all the flexibility that we need, and that we can also pull it out of order so that the planning board can come participate and go.
Mm-hmm. I mean, the agenda won't be posted until Thursday, so rather than taking it out of order, I can just purposely put it that way if that's something you would prefer.
Yeah. The only reason I'm thinking is that there have been so far a substantial number of people to talk about Finn Park Road.
Yep.
And I have to think carefully about which group of people I will have to put off to get the other group done. I'll spend some more time thinking about it, Tamika. We'll talk in the next day or so about the agenda.
Okay, sounds good.
Thank you. Okay. So, as I say, it'll be there. Yep. You're welcome. Feel free to post. Feel free to not post as you feel appropriate for your board. I thought it was funny as can be that I called us to order when we didn't have it last night in the select board when we didn't have a quorum.
Yeah.
But
which are you still starting at 7?
6. We start at 6 p.m. now.
All right.
Okay.
I will also invite planning board members only that we meet in the BOS room. So if you'd like to be, we have space for a couple more people. We've never had a full boat.
Yeah.
So we can find ways to get as many planning board members as would like to be physically in the room together.
Okay. So, well, I'm not going to promise myself right now.
Don't promise.
It's a real maybe.
Let's just say there's a good likelihood that maybe I
Yeah.
would like to go.
What would,
You guys disinfect.
what would be interesting is if you have any of that language available that you think you might be discussing, if you could get that too
Yes, I will. I'll in fact
earlier.
get our member to send us out whatever she can get us for sample sample CRs, which will have all the sample language we're interested in, I think. And I will also, of course, send you a copy of our marked up document. I don't care about you guys don't have to sign off. Everyone here should be aware of what's going on. So when hopefully we'd be done in one, but I doubt it.
Yeah.
It doesn't feel likely today,
Mhm.
but I haven't read Melissa's CRs.
Yeah.
But it might take one, it might take two, but I hope above hope it does not take more than 2 meetings to get this done. And yes, for those of you who are thinking about it, Conservation Commission is breaking the rule by meeting on Tuesday because it's election day. Secretary of State does not like it when committees meet on election day, but we have other timeliness issues going on that I decided that was the better option than not meeting.
Okay.
And that's just policy. That's for the Secretary of State.
Who cares? Okay. So, any other issues that that really came up?
Not right now, no.
Issues, nothing. Okay. So
thank you for your time.
okay, that I don't know. It just sounds like this could be, I don't know, brought under control, brought into correctness fairly easily.
I'm hoping so.
Yeah.
Okay.
Okay.
We gotta go to 5.
Then I guess back to our agenda. We have a public hearing scheduled for 10 minutes of 7. Do we want to take that out of order since it is after 10 minutes of 7?
Yeah, I think so.
It's the board's call. I mean, there's other items beforehand which may or may not be able to be dealt with on a rather quick,
Yeah.
efficient
4Ps
manner.
not
I
gonna be-
don't know. Or the special permit for the state law can be dealt with efficiently and
Yeah.
go back to the other things, so.
And any objection to going directly to the estate lot public hearing?
No.
Okay. Then,
Rough packet for that, yeah.
yes, please. Okay, we have an application for an estate lot petition by Carol Viner for a state lot special permit for a state lot at 0 Emerald Road across from 11 Emerald Road. So,
Would it be possible to put that up, Peter? Sorry.
I don't have it to put up. I thought you were sharing earlier.
I am. I have, I see the content on the screen. I don't see it.
It's not sharing anymore.
It's not showing anymore.
See,
No,
I got-
Dave, we can't see anything on this end.
Go to the planning board meeting. Okay. Scroll down here and share.
This is the one that I had a situation is, it was pulled out of 61A. Is this the one that was pulled out of 61A? We had a discussion and the piece of property was huge. And I asked where the 61A was.
No, Dick, I think you might be thinking of Glenwood Place.
No, this is earlier.
Oh, okay, sorry.
I don't remember.
Yeah. I think the 61A was was it 6 acres or I can't remember how many acres there was involved in the thing. And, but the field is only so many acres for open space, and then how many acres was wooded.
Mhm.
And I asked for a map from the Board of Assessors showing where the mark is. So how do we not know? Was it totally all taken out of 61A? So it's no more, or what?
I have, no idea on that. I guess the only thing that I was going to say is it's something that, yes, it would be nice to know, but doesn't have any bearing on granting a special permit for an estate lot.
If it's in 61A, yes, you can't do it until it's taken out. And therefore, I wanted to know where the bounds are for that 61A. Or unless, when this thing first came to us, a couple of months ago, or whatever it was, on Emerald Road, 61A, I had mentioned it had, they were taking it out, was it town got any use or whatever, where's the map showing? Where's the divide? So,
I don't have an answer other than I just have to repeat that the grant of a special permit for an estate lot, I don't think is contingent on its status with regard to 61A. And any more
it's
than
agricultural, and if you can put a house on it, you have to pull it out.
that's right.
So
But granting its status as an estate lot does not grant a building permit.
but you are granting the fact that once you say, yes, this is the estate lot, and if it is in the 61A, but we don't know if it is or not, need a map. Need to show how it's divided.
Mhm. I don't know, Dave, any thoughts on this?
Yeah, I wonder if the applicant or their representatives are here tonight, if they can speak to this matter. I do know that there was a request to remove a portion of this property from chapter 61A some months ago. But these particular questions, I would maybe see if the applicant knows or.
Good evening. Good evening. This is Norman Hill from Land Planning. And I don't have an answer to that question. I was unaware that this was 61A land. I don't think it affects what we're doing here tonight. If you decide to grant a special permit, if it's 61A land, they would have to petition to have it taken out of 61A, pay their back taxes. But it shouldn't affect what we're talking about tonight.
To me, it's a question of, we went through this before last night. When 61A comes out or something like that, it should go through the town select board first,
Procedure.
and then there are a sequence. And to me, it should be a Board of Assessors should hand over a map showing exactly where what was taken out and what wasn't.
To the chair, to Dick's point, what I see the town getting backed into and what I saw last night was it's got to be done. I've sold the property. I need to get a house built. By granting these special permits or ANRing property, which we can do, but granting this special permit, we basically back the town in. Well, they've got a special permit. There's no reason why we shouldn't just release the 61A. And
I don't know. I can't buy that either.
well, I heard it last night that wants to sell our property to keep his business in keep it going. So we should do that. There was no thought process into the town's future planning. None of that was even thought about last night. It was blown off as far as I was concerned. We were going to talk about it in the future. I've been on this board 15 years. It's been talked about for 15 years and nothing's been done. So, like I said before, we need to draw a line in the sand, and I'm tired.
These are two different
If I may,
processes. These processes are not dependent on each other.
Yes, this is the same process, because if we grant a special permit, we back the town saying that, okay, we've given a special permit, so, well, why not just release the 61A and let them build?
That's not what I'm saying. Under the Zoning Act doesn't reference 61A. So under the Zoning Act, this is a municipal permit to grant. When it comes to a building permit being issued, all permits have to be issued and all permissions have to be granted. But it's not proper land use to hold up a special permit on the back of 61 because 61 is not referenced in the Zoning Act. That would not be a valid action this board to take.
I see what you're saying.
I think Mr. Hill can maybe speak to that as well from his vast experience.
Okay. Go to my next thing about a slope that's 10%.
I personally, I don't think we have the right to deny a special permit because the land is in 61A.
Okay, I get that, because that's not an actionable finding that you can put into a denial. I get that. Okay.
Correct. The Zoning Act has nothing to do with 61.
Okay.
Two different statutes.
The best way of doing all of this would be if someone wants to do something with a piece of land to start by removing it from 61A.
Correct.
But that's just best way
Yeah.
and not necessarily the only legal way.
Correct.
But what the hell are we gonna do with the rest of the land in Rutland under 61A? If the town needs a piece and it's all undermined prior.
I very much agree with you there. But that's where, and I guess I would say, you know, as a group of town boards, including selectmen, somewhere along the line have got to get together and say, okay, here's a piece of property that's coming out of 61A, and we're going to see if we can get some money to buy it.
Yeah, this is the wrong forum for that, Norm. I'm sorry.
You know, that's what needs to happen, and
Yeah.
it hasn't. Let's just put it that way at this point. I don't know if it will. I'd love to think that it would.
All right.
So
I got
is this a way of starting though?
this one isn't.
May I give a short presentation?
Yes, please.
Go ahead.
Again, my name's Norman Hill. I'm a licensed
Now,
civil
Brad, you're wearing the number 7. DJ,
Got to mute that.
I'm a licensed land surveyor with the firm of Land Planning, and we represent Carol Viner tonight. Carol Viner lives in Colorado now. The lot in front of you is 5.35 acres. It has the 50-foot wide strip of land leading out to it. It has over 50 feet of frontage, and where the house is, the lot is 700 feet wide. So this lot as presented meets all of the zoning requirements of the town of Rutland. And this plan that it's shown on was signed by the planning board back in November. And I'd be happy to answer any questions you may have.
Okay, my only question would be the 5.35 acres. Is that access strip, the 50-foot wide access strip, less than the 0.35 acres? In other words, the area of the estate lot must be 5 acres, not including the area of the access strip.
Yes, yeah, the access strip area is less than 0.35, yes.
Okay.
Yep. Plan's right here. Crossing plan is.
Okay, planning board, any other comments?
I'm guessing this is up to the building inspector when there's a 10% grade on a property going into the wetlands. I mean, this will be for the Conservation Commission. It won't be for us. I mean, that grade coming off of, Emerald Road? Emerald Road down to the culvert is over 10%, or it might be 10% if I'm doing my calcs correctly.
Yeah, that's not very steep for a driveway. That would be a little steep for a roadway, but not for a driveway.
Maybe I'm wrong with my calcs. It's 30 feet long by 30 feet down.
45 degree.
That's a 45. I apologize. My math was wrong. Am I wrong in my calculations? That's
No,
a 40.
No, like 10% is fair estimate.
No, I was saying I think my math was wrong. Is it 10% or is it 45?
No, 10%. Drops about a foot every 10 feet. It's 10%.
Okay. I guess, again, the con will be the deciding factor on the culvert and the replication, all that stuff. That is nuts. So from these, let me see. So is the calc, and I guess maybe I'm not an expert on this, is the calculation the setback from the access strip to the 200 feet, or is it right at the end of the access strip? You know, there's a setback till it reaches 200 feet. Is that where the calculation starts, or is it just the access strip?
I'm not following your question, Pete.
There's a setback once you clear the access strip to equate to 200 feet.
Yes, that's the building setback line. The
Okay.
building has to be set back from a line that is at least 200 feet.
So
It's called the building line.
So the access strip, it doesn't include that property within the pre-building
Mr. Hill,
line.
can you just speak to what the access strip is on your plan as you understand the concept, please?
Did you ask me to speak to that?
Yes, please.
Okay, yeah. So the access strip is 50 feet wide, starting at Emerald Road, and it goes in about 154 feet, and then it angles another 156 feet, and then it opens up instantly to about 328 feet. We've got a line on the plan with arrows that show that we have greater than that required 200-foot width once you get past that 50-foot access.
Okay.
That's what I was looking for. Okay, thanks.
Any other questions, comments from the board?
Let me just read this.
Any questions or comments from the public?
Yes, we have one. I believe the party's there. This is from Mary Cockins at 11 Emerald Road. Her question is whether or not there are any legal controls concerning the estate lots to prevent the buyer from subdividing. I
Okay,
think that has to do with the 5 acres.
yeah. Okay, once the estate lot special permit is granted, that estate lot can no longer ever be further subdivided.
Correct.
Is that answering your question?
Yes, I'm Mary Calkins, 11 Emerald Road, that's speaking now. Looking at your map, it looks like the lot, that's the estate lot, is the one that's set back from the road. So there's still 4 other lots that have road frontage,
Right,
That's-
if I'm correct.
yes.
I guess there's nothing that we can say or do that's going to prevent any of this development from occurring. Am I right?
The lots are all legal lots, and assuming we do decide to grant the special permit, the estate lot will be a legal lot. With I guess the caveat of the question of the 61A status.
Yeah.
of the property that Mr. Williams brought up.
Because these lots have had for sale signs on them for quite a while now, and there's 3 of them that already say sale pending, so they're already going forward with it, whether it's approved or not, as far as I can see.
Yeah.
Well, 1, 2, 3, and 4 already been A&R'd, correct, Norm? If I'm not mistaken.
Yes.
That's correct. Yep.
Yes.
They are already considered recorded lots with the Worcester Registry of Deeds.
Yeah.
So then,
However, it still appears that there's something of a mystery as to the 61A status of
Correct.
this
Correct.
whole parcel.
Yes, so they could.
how could they go forward with this if it hasn't been taken out of 61A yet?
They
They
legitimately
can sell it, but they can't build on it.
Well, they can't get. All they can do is get a purchase and sale on it. They can't move
Right.
forward any farther than that.
Right.
Does the building inspector know this?
I would think he does.
Can I have that in writing?
You'll have to ask
Willie.
Willie.
What about the wetlands there? Was there anything there that could prevent them from being able to develop it? Because I know that Helen was very concerned about preserving this land when she was alive, and I guess it upsets me quite a bit that they've made this decision.
Comment on the conservation.
Yeah.
I don't know. We do have a member of the Conservation Commission here. I don't know if he would like to comment on any possibilities regarding wetland problems.
Peter Crane, Chair of the Conservation Commission. I will say that I have not looked at the plans. I haven't evaluated them. Conservation Commission its duty is to protect the wetlands, and we have to allow work to proceed that meets the requirements of the Wetlands Protection Act. That's a very vague answer, and I apologize for being vague because some people have viewed Conservation Commission as someone who can just stop any work, and it's not that simple. If the project that they are proposing suggests harm to the wetlands, then we can reject it. If they work around the problems in the wetlands, and there are a number of ways to do that, then Conservation Commission will have no choice but to grant an order of conditions for the work, which is our equivalent to a permit, simply because that's what the law says.
Again, this is Norman Hill. We will prepare and submit a notice of intent to the Conservation Commission probably next week if this special permit is granted.
Hi, this is Elizabeth Hussey, 97 Turkey Hill Road. Just to the point of 61A, I do know from my cousin's experience that building went ahead before the 61A was all clear and created a huge mess. So I do hope somebody is going to take personal responsibility to make sure that it goes the way it's supposed to.
I know when they go to pull a building permit, the building permit has to be signed off by all departments, including the tax collector and the assessor's office. So they should certainly pick up on it at that point if the building inspector doesn't know.
From the special permit, Norm, I don't see any. I've read the documents. It based upon our bylaw. I don't, and maybe I'm wrong, but I don't see any findings that the 50-foot access. It's they filled the form out pretty well from what I've read. It's got the access strip. It's above 5 acres with the deduction of the access strip. Mm-hmm. From our bylaw, I don't really see anything that could be a negative finding at this point.
I guess I'd have to say that's my feeling as well.
So, I mean, it doesn't hurt in our minutes if we would send a note to Willie to bring the issue to him. I'm not saying we're telling him what to do. We're just simply, as part of our discussion during this process, wanted to make him aware that there's a potential that this property, this special permit we're working on could possibly be in 61A. I don't know if we can do that, if it's...
Well, somebody's got to.
Well, I don't disagree. I just...
Like I say, I'm getting
I guess I would say,
disgusted with this.
possibly very, very carefully worded. I feel that Willie is a pretty on the ball guy, and
okay.
Let's just say I don't want to in any way imply that he is not doing his job as he is supposed to be.
Okay.
So like I say, yeah, maybe we could come up with a.
I mean, it could simply be said to him that came up in our discussion, and we were curious if this is 61A, could you get back to us? Then we're asking a question. We're not demanding or telling him anything. And it could be an answer to us at our next board meeting, just for information only.
I'm just, well, I don't know. The thing is, it's, who's going to actually determine whether it is in 61A or not? That would be the assessors.
I know it, and it should go through them first.
So maybe that's really where.
Okay, I'm fine with that too.
I guess the question might be asked.
Does that go through the assessor or the board of assessors?
Well, the assessor's office is one of the sign-offs on a building permit.
Okay.
Whether it's specifically the board or one member, I don't know their process, but they do have sign-off authority.
Okay.
Yeah.
Or for that matter, rejection authority.
Call to assessor tomorrow. You know what? I'll keep the board out of it, and I'll make the call tomorrow. I'll do it myself.
Okay.
Tomorrow?
Tomorrow. Call him tonight. I don't think anybody will pick up. I'll call tomorrow and ask the question.
Okay. Okay, do we have any further questions or comments from anybody regarding this?
Well, I'm still borderline. I'd like to vote on this thing, yes, I feel that it is part of the thing, but for crying out loud, too many times this thing is snuck by. And it's getting away from being properly handled.
I can 100% understand how you're feeling about it, and how, yes, it seems as though things maybe aren't always occurring exactly the way they should. But I still have to just kind of sit back and take a look at, number one, what is the planning board's role? And number two, what is the planning board's power in this matter? And I'm just going to go back to, I don't think we have the authority to deny a special permit on the grounds of a question of 61A.
I did have another question, Norm, which I don't see on this plan. This is from Mr. Hill. I see on this plan that you've got wooden, I'm guessing these are guardrails?
Yes.
So, and there's a culvert box. So is that just going to be part of the driveway, or is that a bridge?
It'll act as a bridge. It's 6 feet wide and 6 feet tall. It goes in the ground about 2 feet, and then the bottom 2 feet get filled with the natural wetland soil, so that the fauna and can survive and pass through without any harm. It would be built as part of that driveway.
Okay. It was a question. It's nothing that, I guess it was more of just a question on it. So it was curiosity, because I looked at this. You gave us all the maps and or all of the drawings, and I just was looking them over. So
I did. Okay.
And I've got one outside question for you too. This doesn't pertain to this, but I noticed that you've got a stamp on these drawings as a civil. Is some of your background environmental science, or do you need that for stamping some of these some of what I considered wetlands replication stuff like that? Is that a separate stamp, or as a civil you can do that?
If you have enough experience, like I mentioned, I'm a licensed land surveyor and a licensed civil.
Yep.
But I'm flagging and doing environmental work since the beginning of the Wetland Act was first brought in. So I've been to every DEP seminar. Every time they issue a new regulation, they throw a seminar, and I've been at every seminar from the beginning, and I'm quite expert at wetlands.
Excellent, thank you, Mr. Joel. I just was curious because I noticed that the state of Massachusetts has a PE stamp for environmental, and I just wondered if civil, some of that expertise falls into civil too. So thank you.
Yeah.
Good. Need a motion to close the hearing?
Well, once I'll just ask one final time. Any further questions or comments from anyone? Then I'll entertain the motion to close the hearing.
So moved.
I'll second that.
Any discussion? Whatever that was.
Huh?
Okay, roll call vote. Marilyn,
Aye.
Sean,
Aye.
Dick,
Abstain.
once again,
Abstain.
abstain. Tim,
Aye.
Norm, aye. Are we ready to entertain a motion to grant the special permit?
I would make a motion to grant the second, special permit.
Do I have a second? Was that a second?
I'll second that.
And we have a second. Once again, any discussion on granting the special permit?
I guess I'll ask before we do that. David, you reviewed their application, correct?
Yes.
Was there anything in any potential negative findings that you saw?
I'm going to leave that to the board as well to be the final fact finder.
Correct. It's just
But on an initial pass, I mean, we can go through it if you like.
no. I'm just this general question because I didn't see anything. So
Well, it
that's
sounds
reasonable.
like it's maybe needs some nuance to the answer. I mean, we requested the applicant provide findings of fact in the several sections of the zoning bylaw. There's the specific requirements for the special permit. Those are the ones that are very much fact-based. 50
Okay.
feet of frontage, 5 acres of the.
Okay.
Then there's general findings of fact. The applicant provided information for every single one of those. There's design criteria that the applicant provided findings of fact for those.
Yes.
They're a very extensive list. There was nothing that I would, we
Consider.
didn't go back and seek more information from the applicant on any of those, certainly. If the board sees differently, maybe we should talk about the findings now.
No, I just was trying to find out in a general statement. I didn't see anything negative in the application.
I tend
So
to agree.
okay,
Right.
that's what I was looking for. Okay, that's all my discussion I had.
Okay. Anything further? Way of discussion. Hearing none. Once again, roll call vote. Marilyn,
Aye.
Sean,
Aye.
Dick,
I'll go along with aye.
Tim,
Aye.
Norm, aye. Okay.
This was, if I remember right, Norm, this was a super majority, correct?
Yes.
Okay, so we had to have 4 or 5.
Thank you very much. Everybody stay well.
Okay, very good.
Thank you, Mr. Hill.
Good night. Have a good night.
I'll make this call now.
Okay, back to,
Hi, Norm. This is Julian. I'm sorry. I had a hard time getting onto this tonight, and I don't know what I missed. I must have missed something.
you haven't missed much.
Oh, well, that's good.
We had a couple of things that we had to kind of take out of order. So, among other things, we have not yet gotten to the Welch Ave ANR.
How about the Campbell Street?
I don't know. Oh, it is.
No.
Okay. All right. I'll wait till here.
Should we go back to number 3 and start from there, Norm, and get through that?
Well, that was going to be my next question. Should we go right back to the beginning and start?
I think we should. I think we've taken everything out of order.
I'll make a motion to accept the minutes of August 11th.
I will second that.
Is there any discussion? No. Hearing none. Roll call vote. Those in favor, Marilyn?
Aye.
John?
He was,
Norm, if I know,
Aye. Sorry about that.
he wasn't here.
Jason,
I believe Sean and Tim will have to abstain on this one because I don't believe they were present.
Abstain. I got to abstain.
Okay.
Dick Williams, aye.
And Norm, aye.
Okay, voted.
Okay, adjacent town notices. We have a notice from the town of Hubbardston. Anybody interested?
Well, is this Chris Curtis's father? Number 1.
Mike Curtis?
Probably got nothing to do, and it's just general, because I think it is. The guy on Route 68,
Oh,
right by the bus company. I think this is his father up there.
could be.
Yeah. The other thing is number 4. Did you look at number 4, Norm?
Number 4 on the Hubbardston thing?
Yeah.
To include conditions that associate members to the planning board. Associate members? What's that?
Is that a like the bylaw subcommittee?
No. I know we do have, well, I shouldn't call them associate. We do have some boards in town that have alternate members.
Yeah, the Ag Commission, which I'm an alternate.
I have no idea what associate necessarily even means.
Okay.
No, Norm, I think that Barry has alternates to their planning board. So that's probably what Hubbardston probably has that as well.
Is Hubbardston?
They're not elected.
They're appointed.
No, they're appointed.
Yeah.
Yeah.
Auburn does that too.
Okay.
A buddy of mine, he's an
It's an
appointee.
appointment.
So they've got alternates that they consider associate members then probably.
Okay.
I'm good.
Yeah, we'd have to actually read their bylaws to understand their structure.
Yeah. All right. No idea.
Well, it's just interesting, that's all. Okay.
Okay, ANRs. We have land on the northern side of Barre-Paxton Rd, Jeffrey Cronk.
Hopefully somebody's here to explain this to me.
And this one is a little bit different in that it appears that there is an existing non-conforming lot and they are adding some property to it, I guess. Do we have the applicant or representative here?
Are they adding or just splitting?
Yeah, that's what I'm trying to figure out. It looks like, again,
Looks like they're splitting.
yeah, that's Norm. That's what I was looking. It looks like they were taking a long piece of property that was equivalent to the Brussos and the Nattel's property, and they were taking and splitting it into parcel A and lot 1.
And they've got it on the thing, it looks like not a buildable lot. But is it a,
This is my confusion.
Does someone have the parcel ID?
Yeah, the parcel ID is, it was listed here. Let me find it quick. I thought they had it listed here. It's on the front page.
Assessors, you mean?
It's assessor sheet
Okay.
35,
A8.
parcel A8.
It's down near the Paxton line.
I pulled up the assessment map, that's it. I'm not trying to follow along here. Get different views in this now.
And I do believe,
So I guess, Peter, when you pull it up, is my assumption correct that it's one big long lot that goes the whole way back?
That is correct, because
And they're breaking it up into lot
880 feet back from Barre-Paxton Road to
looks like Commonwealth of Massachusetts property.
yes, it's a forested lot.
Yep, you are correct. Oh, 894 is what they're saying on one side, and 883 on the other, or 8 something, or 800 and
895 on one side, 880 on the other is what the map I'm looking at.
And so I'm viewing this as they're breaking it up to parcel A, which is a non-buildable lot, and lot 1, and this is where my question came in, Norm, is should that say non-conforming lot at this point? Because we can't leave it as lot 1 because it doesn't have the frontage. It has the acreage, don't get me wrong, I see 1.5 acres, but
It doesn't have the ability to get to it. It's landlocked.
parcel A is, yeah, that's correct.
You can't come in from the back.
Unless he granted an easement for back property for driveway access.
Well,
Clearly not part of the plan before you
it's
tonight.
still not buildable. It has no frontage.
Yeah.
Okay, and it's correctly labeled as a parcel and not a lot.
Yes.
Okay.
But my problem is with the if we would grant this ANR, are we, and again, I know the wording that what we sign off of says it, if it doesn't conform, it's, but I'm just saying, should that lot 1 say non-conforming lot?
But at the time it was conforming.
Yeah.
But when he breaks it up, it's not, he's breaking it up to,
No,
go ahead.
so they're not doing anything to affect the frontage. All they're doing is affecting the lot area. It's a pre-existing non-conforming lot because it was laid out before zoning. It's non-conforming with respect to frontage only. This A&R has no effect on the frontage. The frontage is not being reduced in size to make it further non-conforming. The only thing in play here is a parcel is being conveyed to an adjacent lot. Meanwhile, lot 1 would still be in compliance with area. There's no note that's necessary for this because there's no effect to the frontage. So lot 1 still remains a house lot. So there's no issue here with respect to this A&R as far as
It's non-conformance has not changed.
Correct.
Okay, that's what I was trying to get at because okay, you're right. It wouldn't matter anyhow. I'm just saying because he's making a change to the property, he doesn't get to go back to 1949 and say I can do what I want. Is what I was trying to get at.
No, this lot meets the requirement for area after the lot conveyance. As you'll see, the requirement, it's an R60, so it meets the area requirement, even with this parcel being split off.
Yeah.
There's no effect to the frontage. So the non-conformity is not being exacerbated through this.
Okay, I'm fine.
Conveyance. It'd be one thing if he was going to be reducing it from 137 to something less. That would not be a valid A&R.
Okay.
It's unfortunate that the applicant is not here. They were certainly aware of this proceeding tonight. I had correspondence this afternoon. As you can see with my question to the applicant, verifying that in fact it's a non-conforming lot, which they did by an email.
Okay.
And did you say something about the fact that it was going to go to a neighbor? the upper lot, parcel A rather.
Parcel A is being conveyed to Wozniak, the abutting property owner,
Okay.
as indicated by that Z, the dash, the Z line.
Yeah.
Can you repeat that, Dave? The parcel A is what?
If you look at the plan, you'll see what looks like a Z. That Z indicates that parcel A is going to be conveyed to the abutter. In this case, the abutter is Wozniak.
Oh, okay. I gotcha. Thank you.
Okay.
And isn't that Mann's?
No, it's
Fred Wozniak, isn't that Mann's?
I kind of think so.
Yeah.
I'm not going to say that.
I'm pretty sure that's his name.
okay. I'm good.
You want to see the GIS map for this? Or?
No, I'm good. Me personally, I'm good. If everybody else does, that's fine.
Mm-hmm.
I'm fine with this now.
Peter's got it there.
Got it up and go and show it. Yes, no?
Yes.
Oh, I'm sorry.
Any more questions, comments? I'll entertain a motion.
I will so move.
To endorse? To endorse, Marilyn?
I will so move to endorse the is ANR.
It's a lot of wetlands.
I'll second that.
Okay, we have a motion and a second. Any discussion?
Okay, that is.
Okay, hearing no discussion, roll call vote. Marilyn?
Aye.
Sean? Dick?
Aye.
Tim?
Aye.
Norm? Aye.
Now got it. And we're in the number 9.
Yeah, we. Right.
Okay, next.
We're B.
4B, we have A&R on the petition of the Carl and Bonnie Bessie for an A&R plan on Welch Ave. And this is a continuation. And I guess first thing to mention, we decided that we really needed to send this out to town council for an opinion on its merits for endorsement as an A&R plan. We have received a reply, and I'm just trying to think of, we have a 2+ page response.
Yes. That quotes. I'm having a
And I
brain.
really don't want to read this whole 2-page thing because everything it's going to, everything is going to get lost in all of the language.
Yes. Maybe we should ask if all the planning board members have read the email.
Yeah, has everybody had a chance to read this email?
Yes.
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 And I guess on, I guess
Sean moved it.
particularly on the second page of the email, the second full paragraph down, it maybe kind of, sort of at least summarizes and starts out further. I note that lots 1 and 4 do not appear to meet the planning board's notice dated January 10th, 2018, whereby the planning board states the plan showing lots with illusory frontage will not be endorsed. The shape of the lots 1 and 4 appear to mimic those of the lots that were subject of the Gifford case. If lots 1 and 4 have illusory frontage, the plan as a whole cannot be endorsed.
Correct.
And like I say, that's, without reading the whole thing, I think that kind of sums things up. So, comments on this from the board, first of all.
I agree with Amy from the start. Yes.
Norm, I have the same opinion. I question it, and she reinforced it with case law in her opinion. So I've got my votes.
I have a question for the board.
Yes.
About probably 6 months ago, we were before you with a plan, actually for Bessie's, down the street and around the corner, and we had frontage on one of the cool sandy beach roads, and then there was frontage up down on Turkey Hill. And the question came up, if we have so many feet on this road and so many feet on that road, there's nothing in the town of Rutland that says you can't as long as you have the accumulative amount of frontage, it is frontage. And at that meeting, the board was, we do agree with that, and we don't like it, but we should do something about that. So where did all that thinking go in this? When I can go back and take that 200-foot piece where I show 200 feet of frontage plus the other 150 and put 50 feet on that side, add them together, and I got 200 feet. Your laws don't say you can't do that. And that's not illusory because I can get from the street to the lot. So I don't agree with the attorney at all. I really can't speak much on that right now because I haven't been issued that, or that email wasn't sent to me for me to look at. But I don't think it's correct on if you guys deny this. That's not right. We have frontage and we can get to our lots. So.
Oh, I'm just thinking because somewhere in here, Dave, do you recall? I could swear that somewhere in here she mentioned that it can be assumed that frontage must be continuous.
Yeah, that's on page 1, the first paragraph.
Yeah. It's after however, Norm.
And also, as far as illusory, that wetland down there is actually not an ORW. It's a regular Commonwealth DEP wetland. We haven't gone to Concom, but you can fill up to 5,000 square feet of that type of a wetland to access your property. And if we did go that route, the first thing the Concom would say is, why don't you come off of Welch Ave instead of crossing a wetland? I'm not trying to mix two boards because we should never mix the two boards, but you're denying it because there's a wetland there, or you're saying that you're thinking it's illusory when you can't because we have a way to get to where the house is going. So I'm just putting it on this end. I don't think Bonnie and Carl are going to walk away from a buildable house lot when you can get to it. Is easier than most lots that I've seen, even including the one you just signed for the on Emerald Road. There's a wetland on that one that split the whole where the building lot is. How can you approve that one with a special permit and then say no to this one? It makes no sense.
No, to answer your question, there's language, in my opinion, the required frontage should be continuous, as discussed below. You have that?
Yes.
Okay,
It's
this
the first,
was
it's the email itself. It's after the from sent to part. It's the first paragraph.
the very first paragraph. Okay. Okay, that's the question that you asked.
Maybe you have a different version. I'm sorry.
Yeah.
So where does it say it has to be continuous? I don't think it says anywhere, as I looked.
Okay.
I know you would like to have it, but I don't think it is right now.
Okay, Sean or Marilyn, do we have any?
Yeah, if I may, through the chair. On the last meeting, Julian, I thought he did kind of win the argument, but do we have anything actually stated about the frontage has to be contiguous? I remember quite a few meetings back, that word came up a lot, but is there anything on the books saying that it has to be?
Law. Case law.
Okay. Okay.
What case law says that? That it says
Guilford versus
contiguous.
Planning Board of Nantucket.
In Nantucket? You're comparing Rutland to Nantucket about
Very case law
contiguous?
we're talking about.
Well, it's not that we're
A lease
comparing,
area is
Julian.
frontage and you can't get to your land from the street that you access to. So if I had 200 feet here and I had 1,000 feet around the corner, and I couldn't get to my lot from that, or I had 199 feet and I had 1,000 feet around the corner, I could go through that other piece to get to my house. It's as long as I can get to the land from the street for safety, like Norm had said, for fire, safety, access, delivery. I can. I proved it with my sketch. So it's not a loose area, it's there.
From where on this land, from where you're putting the 200 feet, you can have safety around that property to that house. You're talking about accessing it from Welch Drive from another portion of that property.
Up there, like in the announcement book?
Yeah.
Oh. Well, he wanted me to bring these for him.
But it was very hard to hear them on this end.
I'm not gonna argue.
Okay. Yeah, the main idea was safety, and since both ends are on the same street, unlike the issue that was brought up when we first started not to accept these through this property owner, I'll leave him unnamed. His property was on the other side.
Don't eat anymore.
And there could have been some difficulties for EMS or services to find the address. But with Miss Bessie's property, both ends are on the same street. So I don't think that part could be argued.
Sean,
my only concern now is law, right? And I'm not wanting to break the law, and I don't know if we have the right to do that as a board.
We've asked town council her opinion. She gave it to us. It's up to us.
Yeah.
Marilyn, any comment?
I do tend to agree with what, I think it was Dick that just said we asked for an opinion and we got it, so. And I do have some concerns that the legality of being the two frontages being so separate.
I'm just kidding.
No, that whole. I'm not a land surveyor, so Julian, so forgive me. But why couldn't couldn't that property be broken up into even sizes instead of having to go all the way around with lot 1 and 4?
We're trying to use the good land and avoid environmental issues by the sketch I gave you guys shows the exact layout of how the houses are going to end up. So it shows that there's plenty of frontage between the houses. All other setbacks are met. They're on a curve of the road. I did soil tests. Everything, they just fit in there perfectly, except they're a little shy on the 200 feet. But the Bessies own 100 acres of land there, and the frontage goes out down the road and then around Cedar Road and up around Turkey Hill Road. I mean, there's frontages in different places, and they're just using it up for this piece of property. So, and it's not illusory, and that I hope that's not what the board's going to not vote on this in favor, because it is illusory. That it is not illusory. You can get to the house from the street without any problem. There's no wetlands to cross. There's no ledge to go through. There's no sight distances issues. It just works perfect. So
okay, Julian, I don't mean to cut you off. I don't have that case in front of me, but that case that stated, was the access on a different street? Was the frontage on a different street when that when it was labeled illusory? Does it say?
I believe it was, though, if they're talking about the one in Nantucket. They were dogleg
Yeah.
in another area. And they...
Because I think the main concern is really not how the lot looks. It's how, measures of safety and access can be made. So if that other property, with the example, of being on 2 different streets, or and this property is not, like I said, I don't, as much as I don't like the way that property looks, it still meets safety requirements. I don't think anybody would get confused. Now, maybe later down the road, Rutland may have to adopt some type of bylaw for, rectangle, postage stamp, California lots. But as far as this issue goes, I'm going to have to agree with Julian on this, because to me, I don't think safety is going to be concerned here. I'm just going to leave it at that.
I can argue.
Okay, well, I think we've heard from most everybody. I'm still struggling a little bit. And I guess most particularly, we asked town council, gave an answer, and I think we might be rather foolish not to follow that. I do still have to fall back on my previous statement that there is no doubt in my mind that there is no concern for safety, service, or the actual access to those lots. It's, I guess I'm going to say, the denial, at least in my opinion, assuming I'm going to vote to deny, is technical only. It's not rational. Not at all rational. It's strictly technical, according to what town council says, the law says. And like I say, I'm really struggling with this. Not I'll tell you, not that I ever want the town to have to defend itself in a lawsuit But boy, this would be one case where, deny it and let them sue us, and let's see what this particular case would bring. Like I say, I don't want that to happen, but boy, oh boy, it would be
Right.
I guess I'd love to see someone with a lot more smarts than this planning board to really decide it.
Well, if we could, if I may through the chair, if we could ask the attorney, I'm not that I'm trying to find a loophole, but if the frontage was on a different street, then maybe legally, that, I don't know what the word in legalese says that you can, okay, well, yeah, you got that one. But I just think it means before we can deny this property owner use of her land, it needs to be further looked into. Or you can, I don't know. It is a thought. Wait, was there a time limit? With this ANR doing it.
Well, yes, we would.
Yeah.
We would have to.
You guys realize the illusory part that you're saying, only a portion of this frontage is illusory, not all of it. And the part that isn't is accessible. So that's where I'm hanging my hat, that there's no way you can say it's illusory frontage and deny it on that basis, because you can get to the land, to where the house is going. So,
And the frontage is on the same street.
and the frontage is on the same street.
Yeah, that's.
I would go back to how the question was posed to the lawyers. We have that.
Yes. Basically, the second page is David George's email to Amy that pretty much outlines what he is looking for.
Could you read that? Because I haven't seen that, and I don't know what the right question was asked, and you're getting an answer that is bringing this the wrong direction.
Okay, he just gives some background. First of all, the question is whether the ANR should be endorsed. Period. He gives some background, talking about the 4 lots, this lot size, the area requirements, the 200 feet of frontage, that kind of nice stuff, and so forth. And then he says the applicant believes the ANR should be endorsed because the frontage is adequate, since there's no requirement that frontage be continuous. If you could advise us as to how you interpret the zoning bylaw definition of frontage and determine whether the ANR should be endorsed, that would be appreciated.
And you attached, David
And
attached.
he attached both the original plan and the enhanced, or whatever you want to call it,
Marked up from
conceptual
Julian.
plan that you provided us.
If I may, through the chair, is this something that the ZBA could get involved with before it would go to land court?
We have control over ANRs, the ZBA doesn't.
Well,
okay.
I mean, maybe I'm wrong, but
they probably could apply for a variance to the frontage requirement.
correct, but
I hate to put the burden on them and kind of, escape through the back door. I don't know.
you just gotta.
I'll leave it at this. That I feel that this should receive a go, in my opinion. And then with, I don't know, conflict, is that the word? But I think it meets. And this doesn't actually meet, what, and I don't know about the Nantucket one, I'll have to see the maps and stuff. But at least with that last builder that built, the reason why we went through all this in the first place, this is nowhere near that. And there's other builders in this town have done. And then we can focus on lot structure in another meeting.
Okay, any other questions or comments? Is there any appetite for any kind of further investigation on this?
Any kind of what?
Any further investigation?
I see none. The only thing I would say is if they want to withdraw it
And redo it.
it's up to them. If not, we'll vote on it tonight and see where it goes.
Okay, nobody else? Well, I'll entertain a motion.
I'll make a motion to endorse this ANR.
Do I have a second?
Could you repeat the motion? I just want to be perfectly clear.
I moved to endorse it.
Endorse. Thank you.
Once again,
I'll second it. Can I second it?
Oh, no.
Committee. Wrong committee.
Once again, do I hear a second? I do not. Therefore, we do not have a motion. I'll accept another motion.
I guess the only other thing is motion to deny. I'm sorry, to deny the ANR.
Okay.
For lots 1, 2, 3, and 4.
Okay, I have a motion to deny. Do I have a second? I have a second. Is there any discussion?
Norm, I missed who seconded.
Dick to second it.
Thank you.
If I may, would it be to deny or not endorse?
I'm sorry, I apologize. I will correct my motion. It's a motion to not endorse.
Okay, I don't know if it makes any difference or.
Okay, I'll just make sure.
Anyway, okay.
I'll make it correct, English.
And you'll resecond that one? Okay. Any discussion?
Well, given that we did ask for a legal opinion, I think there's probably a precedent somewhere that we should consider that considerably.
Do you state why you're not endorsing it in the second?
I'm not doing that. I'm motioning to not endorse ANR.
With no actual reason why?
Legally, I don't have to.
Okay.
I'm not entirely sure about that.
Well, I will wait to find out because I don't think we've never, at my time here, we've never not endorsed.
I know.
And so I'm not going to say anything because until I get some type of town council of what I should have done, what I should do, and I think I need to know if we should have to do.
If I may, Tim, you did.
And a lot of town money.
If this would have been designed right, it wouldn't have had to go this way, but
It was absolutely designed 100% correct. You guys have endorsed 100 of them that are like this, but I'm not going to get into that.
Mr. Chair, did town council specifically advise to not endorse
based on lot 1 and 4.
for those? Okay.
For those, but-
I'm just asking because that would be a reason based on
Town
advice from
council's-
council.
I guess I could do that because she says, based upon lot 1 and 4, you cannot endorse the entire plan. That is her recommendation. So for a reason, I guess I can do that. I can amend my motion based upon town council's advice of lots 1 and 4 not being yeah, just leave it at that. She's saying that lots 1 and 4 don't meet
Could I ask the town council explain why she says it doesn't meet? Because there's nothing in our bylaws, and I believe I've pretty well searched them, that says it has to be continuous. I'd like to know why she has said that. If we could have an explanation from her, so be it. But she does not explain why. Maybe she doesn't have to. But I'd like to know.
Well, you haven't seen that yet anyway. Correct, Bonnie?
What?
You have not seen the lawyer's
No.
or the, you know, her.
Own my land, and I don't have a clue what's going on.
we need to find out if there's going to be a court case or anything like that. Do we release this document that's from our town council to the planning board before we just
That's
hand out
public
that?
record.
It's public record, definitely.
Did she put on here? Hold on a second. Let me look at this. She put on here private and confidential, because if she didn't, then that is a correct statement.
What I mean.
Nope, she didn't. So you are correct. So yes, we could send this letter to the applicant.
Thank you. But in addition, I'd like to know why.
Hold on a second. The message in this document attached, if any, are intended only for use of addressee and may not be, that is, privileged and confidential. No, it cannot.
Actually, if I could, it's up to the, so this is advice to the board. If the board votes to release the email, then that can be released to the applicant.
I'm not going to.
That's a decision for the board to make, because this is a work product that went to the board specifically.
I read part of the email in public session. So, I think it would be very, very hard for us to say.
If a motion needs to be made, a motion to.
You can't yet. He's got to finish the vote for. There's a pending motion. As soon as that's voted, then the other motion can be made.
So, okay, and just as part of discussion, I had, asked whether there was any appetite for any further investigation on this. Obviously, Bonnie Bessie has brought up a possibility for that. So I just ask people to kind of keep that in mind. Okay. Is there any discussion on the motion to not endorse?
Mr. Chair, Peter Crane. If both the vote to endorse, which has already failed by virtue of there being no seconded motion, and the vote to not endorse fail, what is the status of this project? Is it constructively approved?
Number 7.
I just want to make sure that we understand.
If the I guess all I can do is anticipate. Okay. If the vote to not endorse carries, we're done. If the vote to not endorse does not pass, then, and again, the best I can do is contemplate that we would then be looking for a further extension of the time for us to make a decision, and then possibly some further correspondence with town council. Okay. Did I make that clear enough for everybody?
You made it clear.
I think so. Yeah, that makes sense. So Bonnie would need to us another chance, another extension.
Yeah.
Yeah.
Again, just a reminder, an extension has to be granted, has to be agreed to by both sides.
Correct.
I would agree if you folks will.
I'm fine with that. I mean, do you want me to pull my motion back then? And
Well, you can do whatever you want, but let's just think. If she agrees to an extension, for what?
I mean, what else are we going to ask? I mean, and again, are we in discussion still?
She has actually already asked the question.
Yeah, and see, my problem with going back is that this was a simple question. The board's question is whether the ANR should be endorsed. We can't get more basic than that, can we? I mean, I just don't know what else we can do.
Maybe basic is not the question. What was the lawyer's basis for her decision? It was not in the bylaws.
Bonnie, this is Peter Crane. I did a fast read of the letter from town council, and everything that she wrote is based partially upon the bylaws, but also about case law that has been passed or case law that has occurred in the courts in Massachusetts. We've already mentioned one case, Gifford v. Nantucket. The other one is somebody versus Dighton. Gates versus Planning Board of Dighton. I have not read the reviews. I'm not going to, or the case law. That's much better for an attorney to do. But the attorney's opinion is based mostly upon case law and applying case law to our zoning bylaw. That's my understanding of her letter.
That was for illusory frontage. We don't have that here.
There was part of it was for illusory frontage, and there was a lot more about other frontage concerns, which comes from Gates.
Okay. Thank you.
I think that when you get the letter, you'll be able to process it and at least understand the attorney's reasoning. I'm not asking for agreement. I'm just saying I think you'll understand where she's coming from in her opinion.
The lawyer did say you can endorse some of it. So how do you handle that?
Can't. No,
Why?
Her exact words was, "It's all or nothing." I'm paraphrasing.
She's incorrect.
I've got to go with our attorney.
Okay. We still have a motion on the floor. Is there any further discussion? And once again, a reminder, the motion on the floor is to not endorse the ANR plan.
So does it preclude coming back with a different plan for this land?
That's what she suggested.
Correct?
Once again, Marilyn.
Yeah. My question is, they could still come back with another plan for this land.
Yes.
Yes.
Okay, anything further? Okay, here we go. Roll call. Marilyn.
The motion is not to not endorse.
Correct.
So, yay.
Sean. Are you there, Sean?
Yes, I'm sorry. My phone keeps putting it on mute. No, I don't stand with this motion.
Winner to number 3.
So, nay.
Nay. Tim.
Nay.
Yay, or yes. Aye.
Yeah. Dick.
Yes.
Norm, nay. We have, I believe, a 3-2 vote in favor to not endorse the plan. Which I believe that ends it.
Does that mean, I mean, that was only, sorry, Mr. Chair, if I may. Does that vote require a supermajority either way, or only
It's
for
a
a
majority
Senate?
vote.
It's a simple majority. All right, thank you.
Now, I guess through the chair, I need to ask, do we, which again, I don't, in my term, and I could be just having a brain loss, I don't think we've ever denied a ANR before, so do we need to find findings for that? Or is it just a simple denial and that's it?
No, a letter has to be written to the landowner indicating that the plan was not endorsed with some information as to why that was the case.
Okay, so you're,
Why not use that, the letter from Amy?
It would,
We can.
I would assume our reason would simply be on the advice of town council.
correct. Yep. Then I guess through the chair, I would ask, I know some that you read is read into the record, but the entire letter, we need to find out if we can release that letter, because at the bottom of it, it does say privileged and confidential.
But if I could, once again, it's the board's prerogative to release the work product that was directed to the board specifically. If the board votes to release the letter, then that letter can be distributed to the applicant.
But I guess my point, David, is I wouldn't have that vote until I've asked attorney about that.
I'm positive of that.
Wow. Okay.
As in other cases, when there's been other correspondence that you've had.
Yeah.
Wow.
Sorry?
That's
I
okay.
said if it helps, I concur with you on that by vote of the,
Excuse me, I concur that by vote of the committee, the board, that you may release whatever work product you like.
Okay.
Yeah.
It's no different than in
That
any of
makes
the number of cases for Brice Lemon, for example, when there's been letters, those letters, once they were voted to be released, were in fact.
All right. I've been,
So is there a
I
motion to
personally
that?
I'm making the chair. I'll make a motion to release those documents.
Second.
Okay, well, I have a motion on the floor to release the document in a second. Any discussion?
I'm just advising, and again, I'm going against two people that have done this, but in my experience dealing with positions involved,
And where's the number 2?
potential.
Camden Riley! Nice,
That is a red flag.
Well, it's privilege. It's 2 hour privilege.
No, it's privilege and confidence. I'll read it to you. You know what? I'm going to read this in the record. At the bottom of this email, it says, this message and the document attached to it, if any, are intended only for the use of the addressed and may contain information that is privileged and confidential and or may contain attorney work product. If you are not intended recipient, you are hereby notified that any dissemination of this communication is strictly prohibited. If you have received this communication in error, please delete all electronic copies of this message and attachments hereto, if any, and destroy any hard copies you may have created and notify me immediately. That's what it says.
Well, it's that's right out.
Yeah, but I didn't hear anything, if I may, through the chair. I didn't hear anything in that statement saying that it's not our privilege to not, to give it out. It just says if somebody else received it.
That's right out. If you're not the intended recipient, we are the intended recipient.
Yeah, and so it's all privilege. It's kind of almost like the HIPAA violation. It's not really a violation if I give permission, if I'm the one saying it.
Yes.
Come on, Jackson!
Nice.
Disseminate it.
Peter, I've always not done that without advice of counsel. That's just been my experience.
No.
Again, it's my experience only. It's just my experience. I've never done that without advice of counsel.
I'm sorry.
Okay, we have the motion to the document. Roll call vote, Marilyn.
What am I vote exactly on?
Voting to release the email from Amy
Okay.
Pleasant.
Norm, if I can just jump in though, Marilyn seconded it.
I know I did. I seconded it. So.
So is it a vote?
Yeah.
Okay, I just want to check. I've never had that happen before, so I just wanted to make sure.
And a second is nothing more than a desire to vote.
Yeah.
It is not an affirmative assent of the topic.
Thank you for clarifying, Peter. I appreciate that.
Okay, so once again, Marilyn?
Are we voting?
Good try, King.
I'm getting a baseball game here.
Come on, Dawsonburg!
Oh, so did someone speak to me?
No, we can't hear with Sean's background noise. Peter is muted it at the moment.
Mm-hmm.
So, what are we doing?
We're voting on the motion to release the legal report from town council.
I'm voting against that, nay.
Okay. Sean?
Is he unmuted now?
Aye. Yeah. Aye.
I vote nay.
Dick?
Nay.
Norm, aye. The motion does not carry. Where are we?
I have a question not pertaining to anything but just the law itself on frontage. How does this board view contiguous frontage now? So I know when people come to me and say, I got a piece of land, because there's a lot of pieces of land still left, and I've got 100 feet on this side, and then my father sold the middle piece out, and I've got 198 feet on the other side on that same road. Is that lot buildable, or is that lot not?
Case by case basis, I would say.
Well, this is all right. So it's either yes or no.
No, it is not.
You either agree with it or you don't. The law on the books right now say you need 200 feet from the sideline to the sideline.
What?
You need
What else is
you need
there? What else is there? I mean, this here, might have wetlands, you don't know what else is there. You can't go and give you a definite thing without seeing a plan in front of you.
So you're basically you're saying if there's wetlands,
No, see,
you automatically say you can't use it,
everything.
even though this
It's
is
not
a
just-
planning board, not Concom.
Now,
that's why I say
never
case
mind,
by
I'm
case.
Okay, all right. I just so I know what's going on. I'm not retired yet, so I'm continuing. Right. So if there's no wetlands, then it's no problem.
Well, maybe there's Indian artifacts, you can't do it. Who knows?
or a lot of opinion.
So many all.
Maybe there's a lot of opinion in the way. So it really is a yes or no.
No.
Is contiguous required, or is it follow the laws that are written in the town of Rutland? I've been doing this since 1986, and this is the first time that I've seen this situation come up with this question. When there's more than the required amount of frontage put on a plan and it being denied or not endorsed. I shouldn't say denied, not endorsed. So I just want to know for the future, or if Bonnie decides for me to go look at it again, can I split? Can I follow your rules, or do I have to throw it at the dartboard and see if it sticks?
Well, Julie, we're kind of going by state law right now.
Well, what is state law? State law, they only talked about illusory. I don't have illusory. State law didn't say about contiguous. So you can't say state law. That's not what the attorney's letter was saying. They were talking about illusory. So I need to know for either revising this plan or other plans, there's a bunch coming. I want to make sure that we don't have this situation and I don't want to hold up my client because it's a case by case. Well, is it?
With all due respect, we can't answer that.
Okay, all right. Then that's what I'm going to answer to my people. We got to see if it sticks. That's all we can do. The law says it. The Rutland bylaw does not say you can't do it, but we got to see if the board will endorse it. That's all I need to know.
Yeah, I was just looking at that. Yeah. But I mean, according to our opinion, latest from town council, and I know we said, we're not supposed to release this. Well, sorry. I'm releasing this part of it myself, personally. A quote from Amy Klessel: "In my opinion, the required frontage should be continuous, as discussed below for safety access purposes. Additional frontages over the 200 feet can be in other locations." Period.
So I need 200 feet for a driveway, is what that says, for safety. I need 200 clear feet to have a safe driveway. I don't think that's the intent, but that's all right. Mm-hmm. I've got 150 feet that I could put a driveway in. Nobody wants a 150-foot driveway, wide. So I guess we'll, like you said, case by case. We'll see what we come up with on the next one.
Okay. Okay.
4C.
Proceed. 4C, an A&R, 76 acres on the westerly side of Campbell Street.
It's this section. It's this little triangle.
It says not 76 though.
Okay, this is the Mahan farm. Most of the farm is at the end of Campbell Court. There's a long piece of property this goes down to Campbell Street itself. This is the remaining land that he owns on Campbell Street from parcels he cut out. It has well over 200 feet, well over an acre and a half.
No, this is not it. This is Welch Ave.
Oh, sorry. Yeah, I'm not signing this. Put this back together. Yeah, I'm kidding. Because isn't this for lot A? This is for lot A, right? This is the rest of the remaining 68 acres. So what?
Yeah, that's
Oh, it's a description. Okay.
Okay. So from here on. Oh, no, how many house plans?
They are creating Lot A.
From the 73 acres that they have, correct? Is that the way I'm reading this? So this
Correct.
is the line.
So this lot line right here is the one that's drawn for 68 feet and 68.98.
Yes. That's going to be a lot line for the remaining 68 acres. So this right there, all of this will remain as a 68 acres. Oh, but that's Campbell Court, so that does give access with
So
front.
when you drive down here, you'll find it here.
I guess from an A&R perspective, they got the frontage and they've got the acreage, so I think it's a moot point to me.
Okay, no,
It's the next.
the next step.
Yeah. Through the chair, I have no issues. This is endorsable.
It appears it definitely has both frontage and acreage.
Yeah.
So I will entertain a motion.
Mr. Chairman, I make a motion to endorse the A&R at 21 Campbell Court for Lot A.
I'll second that.
Do we have any discussion? Hearing none. Roll call vote. Marilyn?
Aye.
John?
Aye.
Tim?
Aye.
Dick? Norm? Aye.
If I may, through the chair, I apologize, but my phone is about to die, so if I cut off anytime soon, I apologize.
Okay.
Is there anything that's going to be needed as supermajority? Dave?
Just discussions, right?
Well, thank you, guys.
All right.
All right.
Talk to you soon. Bye.
Okay. Okay.
Are we on to 7? Is that where we're at, Norm?
Uh,
No, we did that, didn't? Or no?
we did the conservation restriction on Maple Hill. I don't believe there
Oh, there
is.
was some reports.
We do have some reports, but I don't think there's much of anything significant.
It's just, Norm, I think, is it just bonding?
Oh, wait a minute.
There's
Yeah.
the bonding issue with Maple Hill that Carl did a revision on.
Yes. Yes. Sorry about that.
There's 2 of them, actually. Trying to figure out which is which.
And it
The
is,
if I could, the most recent one, the updated one is on the top. The older one is on the bottom, and the background is part of that support.
Okay.
so we're looking at the surety revised August 20th, which is for a total of $102,168.66.
And if I'm reading the August 20th, Carl is agreeing with the some of the bullet points from the August 6th bond, that there
I
were
would say
assumptions
yes.
being made.
Yeah.
Okay, good. That's what I thought too, but I just wanted to make sure I was reading this right.
To the chair, who owns the detention pond?
Pardon?
Who owned the detention pond? Was it Susurco?
Would the last person who spoke speak up a little bit? And
Carol, I asked who owned the detention pond on Maple Hill.
oh, okay.
And whose property was it? And to me, we had a picture of it.
Shoot.
And it's empty. I was just wondering, and
Is this back here, Dick, in the open space where the detention pond is?
Well, I think this is very close.
Because I don't see it on the.
See it right here? See that?
Yeah.
Right there? And that's that. So it's in the back here. So here's your turnaround.
Which is right here.
So it's in the back out here.
So it's actually in the open space area then. It's not on the property.
Probably not. Yeah, you're probably right. It's probably back far enough.
So that
If
means
if I could on that question, if you look at the the conservation restriction, there were a set of plans that accompany that document. Those plans are from Maple Hill, and those plans, I believe, show the detention pond as being in the open space portion of the site.
Okay. Up here it is. Oh, I had it.
So it is on Susurco's property then?
It's on Susurco's property.
No, because
His own, but it's his.
I thought he just had this parcel back here. He didn't have this. This open
He owns
space.
that too.
Now I'm confused. No, because this defended plan says open space plan, so that open space has to be part of that subdivision, or this defended plan is not good. Now, who owns it? If I remember right, we had three options for owning: the builder, HOA, and I can't remember the third.
The town.
Thanks. So those are the three builders. So unless Susurco is the builder, which I'm pretty sure that's not correct, it's CB Blair Development Corporation, that detention pond should be owned either by the HOA or town or CB Blair. And I don't remember.
Mr. Chair, if I may, recent conversation with Mr. Blair, he told me that there will not be an HOA. So that's off the table for this property.
Yeah.
So it's going to be whoever owns that piece of property, whether it ends up being Susurco or ends up being Blair Industries, I don't know.
He can't sell open space property to an individual in a subdivision, can he? I guess I'm asking Norm. I don't think that happens.
But it stays with the property though. It's the only thing.
I'm confused on that.
Right,
one.
the CR stays with the property forever.
Yeah.
But open space is not a sellable component.
If I could, if you recall, this subdivision was done by two parties. It was done by Susurco and Blair together. So they were both involved in the subdivision from the beginning.
I apologize, David. I was looking at the wrong thing. The owned by is what you are correct. So Susurco could own that open space because he's part of the owned. You're correct. Yeah. Yep, I apologize. But he is 64, so. This is not having a computer stinks. Or as you say, Dick, the big TV.
Do I have a motion to approve the surety amount for the Maple Hill subdivision?
So moved.
I'll second that.
Any discussion? Okay. In favor, Marilyn?
Aye.
Sean? Sean, I think is gone.
Well, he might be frozen though, which means he might be, he may have dropped.
Okay. If we can't get him, can he be listed as abstaining?
I think that he's not part of the meeting any longer, so he wouldn't, his vote would not, there would not be a vote from him. Because he's no longer part of the meeting.
Right, well, essentially he's left the meeting.
Yeah, okay. Dick?
Aye.
Tim?
Aye.
Norm? Aye. Okay, Maple Hill. And
okay,
we now have Brice Lemon.
Mr. Sheriff, you did have received a report from Quinn from Maple Hill Estates subdivision dated August 22nd, 2020. If you're interested to know.
Okay, and if, boy, oh boy. Do we have that in our packet?
Should be. Or it should be a supplemental, I believe.
Which date was that? 2020, 22?
August 22.
Yeah, okay.
I think it was in the packet itself.
We've also got one from the 17th for this finish course.
That's the price. This is.
Oh, this, I thought we were done with Maple Hill Pond.
Okay, yeah, I remember seeing, yeah. I do remember seeing it. I don't know where it is.
Remember, yeah.
It appears that, among other things, there's nothing going on.
No water in there yet?
No.
Detention pond? The second page.
Right.
Is there any negatives on that one?
I'll have to say to the group, this is the first time I've ever seen a dribble berm.
Yeah.
I don't know what the, there must be a terminology used.
Where the heck did that come from?
Is that rock?
Yeah, well, crushed rock.
I'm used to seeing the, what is that, the black screen, or the, you know, the mesh that they put under it. So that basically keeps the sediment from getting down in there.
Into the thing, yeah.
All right, dribble berm. Interesting.
Well, I think at the present time where you got so much traffic going in and out and dirt and on the thing, and it'll keep the dirt from going down in the sediment, so it's not a bad idea.
All right,
so I see no problems with his
right
stuff.
Okay, next we have Brice Lemon Estates. I'm not quite sure exactly where everything has gone to, but there's been back and forth emails.
I saw those about the wall.
Yeah.
I don't know. It seems as though every time I went in to check my email, there was another half a dozen new emails. And
it looks like we got to do some action. That's the one thing I took out of all of this.
You just try to keep the board informed.
Yeah.
Yeah.
That Carl says that he didn't have a waiver in place.
Yeah.
So that's why I was thinking we need to make some action and dot the I and cross the T.
Mm-hmm.
And to me, at this stage of the game, it's almost up to the HOA. What if you gave them the responsibility?
Ooh.
No. The waiver is for the planted islands.
Correct.
That's not part of the open space.
Yeah.
So I guess, at least in my mind, and I believe this was part of one of Clee's emails, as I recall it, whether this could be considered, I'll call it, let's say, a field change, or as he mentioned, as he called it, a de minimis change to the subdivision plan. And to be perfectly honest with you, I know Gary Kelleher did not want those islands.
Yeah, I know.
I don't know about Joe.
That's true, too.
Well, Clee says he's made a request the waiver. Please let me know what Joe says. This is at 12:55 this afternoon.
Yeah.
So do we basically check with Joe, and if it's a thumbs up, we grant the waiver and get that included in an addendum to the orders of condition?
Is this the only one?
Or to
is
your
this on
point,
all of them?
to your point, Norm, it's a change.
There's at least, what, 3 cul-de-sacs?
In phase 1.
In phase 1? No.
Well, you had Shenandoah, and then it seems to me like you had two, the one way up where the house is and the banking.
That's phase 2.
That one's in phase 2?
Yeah.
I thought that was phase 1. And
Mm-hmm. Phase 1 basically stops almost at the pump station. The first pump station.
that's right. Just up a little bit from that.
Yeah.
Yeah, you're right.
But I believe
But is there one of that?
There's a cul-de-sac in, I think, like phase 5 or phase 4.
Isn't there, it seems to me oh, come on, brain.
Which is off of phase 1.
Just prior to Shenandoah, is it Shenandoah that am I thinking of?
Sedona.
Sedona, thank you. Just prior to it, wasn't there another one that was supposed to go up to the right?
Not prior to it, after it.
After it?
Again, almost across from the pump station.
Okay.
On the right. There's, I think.
Yeah, someplace in there was supposed to be another one.
Right.
But didn't that also have a cul-de-sac in the end of it?
I think so.
And that we have not discussed either on that one, so.
Yeah, but I think that's like either phase 4 or phase 5.
All right.
I mean, I'm okay with just getting Joe's opinion since there's a new chief in town, so to speak. And if he's okay with the no islands for plowing or road preparation, I think we should probably take some action.
Well, yeah, and I guess, first of all, is the determination, is this a big enough change that we need to hold a public hearing and so forth? At this point, I'd rather like to say no, but that's going to be a decision of the board.
We're only doing this on phase 1? We're going to do this for
I would
all?
assume we would do it for all of them, for the subdivision.
Yeah.
if we would amend the orders of condition, does that require a public hearing? Or is this back to the major and minor modifications?
That's it would,
because this really isn't a modification to the plan; it's to the orders of condition, isn't it? Because our bylaw says you got to put islands in there, doesn't it, in the subdivision? So I guess you're right. It could be either.
To be perfectly honest with you, I'd have to go back and look at the plans and see if it shows a planted island in the middle.
We need to check.
I like to think there isn't.
You know, if the plans do not show a planted island, in other words, if they show that they're paved straight across, then we certainly, I think, would be able to conclude that this is just a field change. And it's a
is there,
I don't know, so can we grant a waiver outside of the notice of decision?
No, I believe the waivers have to be granted when the subdivision is approved. But if you don't consider it to be a waiver, if you consider it to be something else that's not a waiver, you have the discretion to move on that item if you call it something not a waiver, which I understand this board has a custom as to how it treats some of these changes. So I'll go back to how you folks typically would handle this kind of thing.
See, the problem I've got is it's in the subdivision bylaws. That's the tough part I've got.
And now it's brought up in paperwork. Therefore, we need to deal with it properly.
Yeah, that's what I keep saying too. But
I don't know. We might need to. Yeah, you know.
Well, it said it is unclear if a waiver was granted or granted, not required landscaping island in the Sedona Circle cul-de-sac.
Mr. Chair, could we pause for just a minute, please? There has been a small issue on back.
Okay.
First.
You say smoke break?
Anybody have a song in their heart?
We're all set. Thank you very much.
We're all set.
Oh, shucks.
Okay. I
think an interesting point here is whether or not it's on the, the original plans, and I don't.
Is it in the book?
Wistful thinking, but I don't remember them being the plans.
Well, I guess our first thing is some research.
Yes.
Yeah. Go back and look at the plan. Go back and look at
and waivers,
communication, and not even necessarily the notice of decision, but even other correspondence.
Clee put something in here, but he just didn't put a date with it. He said he had this something about Gary Kelleher.
Right here, Gary Keller said he did not want any of the islands
in
the cul-de-sac anymore, and I agree they grow into weed gardens as no one takes care of them, and they make it a lot harder to plow. We made a cul-de-sac that way at his request. And
I mean, this is
Carl's
a moot point, Norm. If Clee has a letter from Gary Kelleher telling him to do this, right?
No, because Gary can't do that.
Oh, he can't because it's a subdivision. Yeah, he doesn't have. But if he sent it to us,
well, that's why I say we need to.
Yeah, you're right.
We need to do the research.
Mm-hmm.
Is the we?
Yes, that
I was pointing to is the we.
Take a look.
Yep.
Okay.
Okay. Anything else on Brice?
Well, interesting on the curb. You know, I was run over and the other one stopped short, but Clee says it's in line
With the telephone or the pole.
with the pole, but, you know, why isn't it gone out to around the street?
Is that property sold?
Yeah, people live there.
Oh, yeah.
Why isn't the curb there? It's in front of their property that they own.
Yeah.
Actually, until Joe gets back from vacation, it's
Is he
really,
gone this whole week, Norm?
I believe so.
Okay. I guess the only other question I had is because I had to get a sticker today. I drove by the entrance to the other side of Brice Lemon.
Yeah.
Is that are they just opening that up because it's staked like they're gonna put down a road?
It is a road going in there. Is your hay
Yeah,
bales on the bottom?
I think
To me,
Well, they can do all that stuff prep. I don't have a problem with that, but
Yeah.
my question is it going to be paved? Because I thought we were doing this in phases, correct?
Yeah, that's phase 3.
yeah.
I thought we had 5 phases. Well, I apologize. I thought there were 5 phases, and that was the last phase.
No,
It was just 3 phases?
no, this is, I believe this, it's either 4 or 5. I think it's 5 phases.
Okay.
Phase 1 and 2 go in from Sharnock.
Yep.
Phase 3 comes in from Main Street.
Oh, and then there's the side.
And then there's all the little fingers that go
Yeah,
out.
you're correct. Okay. Good enough.
Yeah, so
But have
to
we?
me, I cannot believe, because I thought it was in our regs. You know, the wetland is just on that other side of that stone wall right there, and how the hell did they get, you know, to disturb all the soil right there? In the picture, this is from today. From
Wow. Is that a storm drain or a?
that's to send the water into the wetland.
Oh, okay. You can't get him excited.
Yeah.
All right.
I mean,
guess-
to me, it does look like maybe it might be some grass starting to grow in the banking, but I tell you, that's an awful lot of open area.
There is.
And to me, I always thought there was only a certain amount of area that was supposed to be open and open space subdivisions at a time. And to me, this is a violation.
Yeah.
Did we do that on Bright? We did on Noble Hill. I remember that.
Noble Hill, I believe, is the first one that we really tied things down.
Really tied it down.
Yeah.
But I always thought in our open space subdivision rules and regulations, it had a certain amount of area.
Yeah, I don't.
But we cut it down for Noble Hill because of the steepness.
Yeah.
Little did we know how steep this one was.
Right. But I don't think we put it in the conditions of approval.
No, we didn't.
So we kind of have to live with that.
Okay. Anything else?
I'll take another look through the regs another day.
We got a lot to finish up. And I'm getting too much
Anything
time.
else on Brice Lemon?
I have not been down here, so I have not taken a look at the rail trail. And I was reading Carl's thing, attached a letter from the structural engineer. The wall was his design to ensure the slope wouldn't be a concern. I wanted it to do a 1-to-1 slope. And to me, that's a 45-degree, isn't it? 1-to-1?
1-to-1 is 45, yeah.
And Willie, the building inspector, wouldn't let me. That letter was what Willie required in order to call that lot safe, as he wouldn't give me an occupancy permit without it. I would like to point out that the lot and buildings there are on a responsibility of the building inspector, not the planning board. If he's satisfied, that should be sufficient. Since the building inspector is satisfied, we won't comment further, is Carl's reply. And to me, wouldn't let me. So what did Will say for the banking?
guess my curiosity is if you have to design a wall to hold up your property, who does that fall under? The building inspector?
That's what they're saying,
Mhm.
yeah.
Yeah.
Okay, interesting.
Yeah.
And if that's the case, but
So does he send that?
But we should have that information in our file. It is part of the subdivision. It is not, to me, the wall is not a house. So how did Will get jurisdiction over that?
A retaining wall is a structure, isn't it?
If it's over a certain size, it's got to be engineered.
It has to be engineered, yeah.
Yeah.
So I guess my question would be, and again, it's to Norris point. I don't want to step on Will and say he's doing the wrong thing, but if I was in his shoes and I had a structure that I didn't have, and I wasn't a PE, I would send it to our town engineer, which is Quinn, to have them review it, right?
I would, but look what he said.
Since
the bill inspector is satisfied, we won't comment further. Mm-hmm. So I want to make sure that we have sufficient in our files engineering for that wall. I'm a little tossed up how, you're right, it's a structure.
Mm-hmm. It's a structure, and it's a structure on a private lot.
Yeah, I'm starting to. Dick, I feel you, man. I agree,
Yeah.
but I'm on the other flip side. That's not our problem. It's the building inspector's problem. So he's got to make that call. If this was on a road,
did we not have something in there on angles?
It was
building a house or housing on the lots or anything like that, certain angles, pitches.
And I think it got wiped out, to be perfectly honest with you. We did have something in our open space about slopes greater than 20%.
Mm-hmm.
But I don't think it had to do with building houses.
What did it have to do with?
I think, I may be wrong, I think it had to do with counting it as open space. That slopes over 20% could, land that had a slope over 20% could not be counted as part of the open space land. I may be wrong on that.
I need to find out.
is that in our subdivision regs?
It should be.
I got them right now. H.
Open space design.
Like I say,
All right.
I do remember something about
yeah,
it, but
and
I'm
I
not
just don't
sure
want
if it's still there.
Yeah, if it's there, I want to make sure we're covering our bases, and something doesn't come back and bite us later. I think that was about all that I had. Yeah. I think that sometime down the pike, do you think it'd be a good idea to have a site walk someday on that piece of property to think about things, like we did on Noble Hill? You only allowed, I think, 3 houses or something like that, 3 to 6 houses. That was it.
Yeah, I don't know if it was a number of, it was either a number of houses or
or certain length.
Certain length, like 100 feet or something on this idea.
Yeah.
Of clearing.
And to me, for crying out loud, when I walked that piece of property before they even, when they logged it, period, how steep it was and everything else. And I remember notifying DEP because I thought that was a violation, and they called me and said it was down there. It's just one of those things. I think that we should have been in there, or I know Carl took a look at it and all that, and we rely on Carl, but I feel that we ourselves should go in there and put it in our head, what it looks like and things like that. So sometime down the pike, if you're writing or doing anything else, hey, remember how steep that stuff was, and
Yeah.
because I remember us saying a long time ago, the good land is gone, and all we have left.
Yeah, honestly, that's
Yeah.
That's kind of true.
Yeah.
And I do have to admit, I have not driven in on the Main Street side of Brice Lemon. To take a look at it.
I did some time ago, and that's when that pump house stunk to high heavens.
Uh-huh.
All right.
Okay. Anything else on Brice Lemon?
No.
Okay, next item. Chapter 61A, request removal of land, property located on Irish Lane and Emerald Road and Turkey Hill Road. Just trying to think where I saw that.
I guess I'm going to start out with the procedure as I perceived it. Did this come from the select board? Or is this?
Norm, if I may, I'm not sure if you guys are aware, but this property was taken out of Chapter 61A back in 2013, and Town Council confirmed that that is the case, and so there is no action required by the town.
Done. Kills that.
Actually, if I could, was it that Town Council just verified the process? That if it has not been active over a certain amount of time, then it's taken out. As opposed, have we received a letter rescinding this from the applicant?
I can look at my email. We received an email from Town Council that specifically stated that this did not require action from the town, that the town, it actually said, did not have a right to have any action on this.
I don't have that correspondence, so
let me look through my email.
The board as if this was still active until we were told definitively otherwise.
Okay.
And not that I want to muddy the waters on this, but I just find this 61A thing kind of, I'll say, a little bit befuddling. Because, and again, I'm certainly no expert on 61A, but at least my understanding now is that if you have land under Chapter 61A, you basically have to reapply every year.
Yes, you do.
Yes.
You have to renew it every year.
I do, every year.
Okay. And if you don't, then it automatically comes out of 61A.
Correct.
And you should be taxed
And
accordingly.
and the taxes, you'll pay the back
Okay.
taxes, and
Which just, if that is a yearly thing, I just find it rather surprising that the town ends up even having to go through people requesting to withdraw their land from 61A. Why don't they just wait until the end of the year?
because
I just sent the email to you. I had sent it to you back on August 18th, so I just re-forwarded it. It's the communication from the attorney.
I'm going to say the application was about a month and a half ago, came to me. I filled it out, put it in there, and you have to have it in before October 1st.
Yeah. But like I say, it just seems kind of strange to me.
Oh, yeah.
That if people just at least look a little bit forward, just say, hey, I just won't.
Yes, I think how I read this is, pardon me.
Go ahead.
So the email is, I'm not sure if this request has come across your desk yet for Chapter 61A request. for James Meager. I wanted to share the information below received from the assessor's office and the follow-up email from town council. So the assessor is believing that this is not subject to this request because of the lapse. And town council indicates that if that is the case, then it would not be subject to review. But we have not received a letter rescinding this from the applicant, so I don't know that this has been disposed of. But I appreciate you sending this.
I know that the select board opted to not even put this on their agenda this past time. They felt that no action was needed, so they dropped it. So I'm not really sure where that goes from here. I don't want to speak on their behalf. This is just the information that I received.
This is me. I'll do the private citizen thing right now. Wouldn't you, as a board, want to verify that?
Yeah.
Rather than just, I mean, as a planning board member, I would, to David's point, until we've been told that it's not, I just would rather go ahead and discuss it and move on.
And if we could also, we did do, I understand that the select board's office did do outreach to the applicant, letting the applicant know of the assessor's opinion and asking the applicant why this should be before the town. And I believe the applicant, they indicated that there's some kind of a tax lien or something that would have to be removed one way or the other. So once again, I think that would be the conservative approach, is to assume that it's valid and make the recommendation one way or the other. And then if it's not valid because this is verified, then that's fine. If it happens to be that it is actually valid, and the board has done what they need to do.
And you just said that the lien, the tax lien, and that's what's on it until X number of years that you've been off.
Yeah.
And you said it was 2013 that they stopped.
That's what I think the attorney said. Yeah.
So normally, I think is it 5 years?
It's five or 6 years of back taxes.
Yeah.
Yeah, I don't know.
Yeah, I just remember. So I guess the question I'll ask the board: do we have any interest for the town planning for this one?
Oh my gosh! Oh, let's.
Listen.
No, I mean, it was said right last night, for crying out loud, that the town's got to look into this and put some forethought. Yeah. Okay. Let me turn around and look at the wall. Hello, town. Will you do some forethought?
You're going to get me wound up again, Dick, and Karen told me to make sure I don't get you wound up.
Anyway, yeah, please. I had a good pain today.
In this case, I looked over the GIS and access to this property. I'm not sure that this makes a good 60, a good, other than the point for like soccer fields and town recreation. I could see this, but for town buildings, that Turkey Hill Road, I mean, in my opinion, isn't great. That's what I'm looking at.
It's not the best.
Yeah. It's not a Prescott Street. I mean, it's 40 acres. The issue I've got with it is it's not that expensive for 40 acres, $500,000 for 40 acres. We were just talking about 4.5 acres for $250,000.
Yeah, I know.
So, I don't know. I mean, part of me, I don't want to let any 61A go because my opinion is, I think the town needs to start acquiring land now in my opinion, we can afford the land as opposed to 20 years from now when it'll be so out of reach, there'll be no way to finance it.
And this piece right here this is the Viner piece right here. And already that's got 4 lots, 3 lots, house lots, and the
4
estate
lots. It's got 4 lots and an estate lot already carved out of it. So
it's in the process of disappearing. This is Mr. Calkins' property over here.
Yeah.
And I think that may stay, but not too sure. But
I mean,
if there was a lot of houses going to, the ability to build a lot of houses, then I would consider the town should have a piece of property maybe there. Think about.
I don't know how to do this.
I know it.
My gut lately is go for everything and see, sort of throw the paper on the wall and see what sticks.
Yeah.
Well, and this is
We don't have a plan. That's the problem. I've got, Norm.
something that I've been thinking about, just as to whether the planning board might be interested in, I'm going to just say, in general, take a posture and reply on these things just generically, that we feel that an investigation as to town use of the property might be worthwhile.
I like that. You were thinking what I was thinking is, we're not saying buy it, but you've got 120 days, discuss it and see if there's any potential use for it.
Put some action into it.
And,
Yeah, I'm fine with that.
Just kind of make that a kind of our standard statement.
Yeah.
When these things come up.
Yeah.
And also a reply. How did you make out with this?
Yeah.
We're giving you 120 days, or here we're giving you 100 days.
Do you need a motion as recorded on the recorder back there, which I can't repeat, that we send a?
Well, I don't know.
I agree with you.
I'm just looking at this one, and I'm just kind of curious.
So they do not have a letter from. Is this what it is? They're saying that the Board of Assessors hasn't sent a letter saying, yeah, they're all out. They've all been taken care of. Everything's.
No, David said that a letter was sent.
It's an email.
Yeah.
An email from the assessor indicating that this no longer qualifies for the Chapter 61A program, but we haven't received anything from the applicant rescinding this, and we have received correspondence from the applicant indicating that there's a tax and some other considerations here. So I don't know if it's valid or not, but if it is.
And here's my problem, Norm. To follow the law correctly as it's set forth for the 61A, we're supposed to get a letter from the select board asking our opinion.
That's what I'm just looking for.
There is none.
I didn't include that here, but we did receive a transmission to the boards and commissions that this had been reviewed by town council and it was in the proper form. I omitted that letter, but we did receive that correspondence.
That's what I wanted.
The transmission did happen the way it was supposed to.
Okay. Thanks, David. Then I guess I'd make a motion to send a letter to the select board indicating that some further investigation and let me phrase that make a motion to send the select board a letter indicating that the planning board has interest in investigating the potential town use for this property.
Or words to that effect.
Or words to that effect, yeah.
And I'll second that to that effect.
All right.
Okay, I guess we have a motion and we have a second on this one. Is there any discussion? I'm hearing the sound of silence here. Yes.
Mr. Chair, I'm actually reviewing the email sent to Concom, and it specifically says on August 4 that a proper notice had not been received by the town at that date. And I don't see anything that indicates that that has changed.
With all due respect, I don't know where it is exactly, but it's my recollection that there was a proper notification transmitting this matter to these boards. This board of commission.
That's fine. I'm just going through my old emails on it. That's all.
And that had been reviewed by town council within the required time. That wasn't.
Now that I've read Mass General Law enough, there's 3 boards that get this: Concom, Planning Board, and Assessors. Those 3 have to respond.
I'll verify that.
And
yeah,
also now AgCom, because they have the ability.
By law, they don't have to, but by town policy, it can happen. But by law, they have to give those 3 boards the letter, and they've got 60 days to respond.
Okay. Once again, any discussion? Oh, roll call vote. Marilyn?
Okay, this is the motion to send a letter to the select board.
Yes.
Yes.
Aye.
Tim?
Aye.
Dick?
Aye.
Norm? Aye. And
Okay.
Sean, I'm assuming it's still among the missing? Okay, next. Rutland Heights Solar Concept Plan Submission. I guess the two of you are probably more familiar with this than anyone else. I don't.
I mean, Norm, honestly, until the grid gives a response, it's, in my opinion, in limbo. The applicant is still moving forward.
Yes.
And has spent extra money to have the grid to do a further study.
Okay.
And Mike had just told me it was like $33,000 or $35,000 additional plus a $2,500 filing fee. So it's still going forward, but it's all dependent upon the grid's response.
Right. 66,000 because of Wheeler Road and the Heights.
Yeah, I don't know about Wheeler. All I
Yeah,
know
well,
about was
that's what they're spending it. That's Soul System is
so.
spending.
I mean, the initial discussion, and I've asked this multiple times. I finally got an answer. Is the grid initially came back and said, "You owe us a substation. You know, $100 million. No one's going to." So
okay.
The point to that being, and I think the select board chairman had brought that up. It probably could kill the development, but we don't know that until the grid comes back.
Yeah.
So
and we're talking about Treasure Valleys, and once upon a time they were talking about a little substation, the one that comes out of Central Tree, that one up there, needing update, and they could turn around and maybe Holden would accept some of our electricity backwards because they're a mutual thing. They could buy it that way too, and that was, I believe, something that, not Betty. What the heck's her name? A solar person there.
Oh, yes.
Consultant.
Consultant.
Peterson.
Pardon?
Peterson.
No.
Diane. Yeah. Diane
Not Diane. Well, Diane might have repeated it, but I'm talking about.
our consultant there?
Yes. Yeah.
Oh, Jesus.
Well, I
anyways,
can tell Mike gave me all kinds of positive feedback about the RDIC's solar consultant that we have now.
Oh,
she will not let the grid off the hook, which I was glad to hear.
Yeah. Norm and I are both on the solar committee.
Okay. You've met her?
And we've dealt with her, and my gosh, she is so great.
Yes, that's what I heard too. I've not met her, but I was glad to hear that because
I can't even remember her name. Honest.
Yeah, I can't remember her name.
Utilities
The
right
only
now.
thing I can remember is that you got to have your brain in overdrive just to keep up with listening to her.
Yeah.
Okay.
Yeah.
All right. Well, that's sort of what Mike actually talked to me today and gave me a quick brief because I had a bunch of questions. So,
okay. Anyway, there's nothing for planning board to do on that.
No. And everything, I mean, the Comcom's already gone through it and they've come up with their orders and everything else. And I'm happy with it. I've gone through a good part of it. I'm not going to say I've read the whole thing, but what I have is good.
I did have, David, one question. Is this conceptual plan for that in a PDF somewhere that I could just take a look at? I had not, or does the RDIC have it and I can request it from? Because the big book,
Tim, I emailed that to you late last week, and I also sent it back out again today. Did it come through?
No, I haven't. Tamika, I went and looked at it, and all I got last week was lot 1 and 2.
Okay. It was giving me trouble with saying that the size of it, but some people got it, so I don't really know what happened.
I got it.
Yeah, I got it.
All right. I didn't. If anybody can forward it to me.
Actually, Tamika, if I can suggest,
Yeah.
that's on the Concom share OneDrive, right?
Yes.
So go ahead and send Tim that link so we can get directly to it from there.
Okay.
You'll have all of our stuff from the last meeting, but that's one of the things that's pretty clearly laid out.
Excellent. I'll grab and just download the PDF. Thank you.
Okay.
Good. I just wanted to read it.
So there's the comment to the RDIC is that the planning board has no comment. I think the RDIC is looking for a comment back.
Oh.
Are they? That was never made clear to me.
Well, I mean, I think it's just part of the advice piece. It's being circulated intentionally to the various boards and commissions for advice. So if there's no advice,
Me to make a motion saying keep going.
Please.
I would simply say we have no comment at this time.
Yeah.
Okay. Number 10, Central Tree Road, Muschopauge Road, discussion of prior development.
Yes. Some time ago, I started realizing, that there was a problem. I had brought it up with the select board at an open session that the owner was getting ready to sell some property, and I had mentioned the fact of the watershed district, and but they didn't care about it, didn't want to, I told him his opportunity now to buy the piece of property, maybe, and keep it for the watershed district, and they turned it down. So there were 4 lots pulled out. The lots did not, the gentleman that runs the water treatment plant thought the property went all the way down to the reservoir, and it does not. There are 4 1-acre lots involved. And according to our bylaw, that these houses are supposed to have a 50-foot setback from the top of the knoll of the hill. And I showed pictures to our town administrator back in February of there were 1 to 2 of them, and I don't know about the other 2, but they all pitch right from the house down towards the reservoir, and that's a no-no. And the only reason why I like I say, I got involved in this thing because I do remember my father and my uncle when they were both on the planning board at the time, and my uncle turned out to to be the building inspector also back then too. So I always felt that keep an eye on that, and it just didn't look right. Like I say, I took pictures. At least one of the houses really shows it, and I don't want to knock anybody or anything else, but I found the problem, and in the thing is the 50-foot from the Muschopauge Pond watershed line. And the building inspector gave me the slip from the engineer, and it said in the thing, first approximate.
Mm-hmm.
So in the past, when it's come before us, I think there's been one other house or something like that. It was built that we had to take a look at on Central Tree a long time ago.
Okay.
But it might have been, like I say, it's a long time ago.
Don't know.
And I thought that approximate was taken out of there. I went back and I asked Nita, and it says our index shows that we voted on May 1979 to amend, add Section 20 Watershed Protection District. And in October of 1993, town meeting voted $10,000 to set the Watershed Protection and Land Preservation Fund, which I never knew. I also noticed in here in the town report in 79 that it was either 79 or 80. I can't remember right now without going back. The planning board hired WPI during the summertime for them to go and mark on a map where the line was. And I have no idea, unless this is it.
Yeah, I was gonna say, what happened to it?
No idea. I have no idea at all.
So you're saying, Dick, this subdrain actually goes in, it's pushing water into the disturbance buffer from these houses. This 4-inch PVC subdrain. So it gathers all the water from the house and then just pushes it down into here.
It could very well be, yeah.
There's 2 of them to do that.
Yeah.
Wow.
So, anyhow, to me, for crying out loud, that is the problem. Like I say, I don't want to knock the developer that put the houses in or anybody. I just want this thing fixed. At first, I was really ticked off, and I want to sue everybody, but no, I love this town, and I want just to fix this thing.
How do they fix it? Is that dirt mound?
Well, that's what I wanted to do, originally, but I forgot who the heck it was. I was telling them, how are you going to get anybody to go to these houses and say, hey, we got to go behind your home and put in a 50-foot from your house.
Cut the yards in half.
Yeah. And so I don't want to set a precedent. That's why I want to fix it. And
so you're saying from now on, Dick, we have to look at that, and if there is a 50-foot
then
disturbance, then that's got to be handled as part of. Is that a building inspector, or is that?
No, it comes before the planning board.
Okay.
This came before the planning board. I was a little upset because
2018.
We did not take a site walk, and I feel that anytime anything to do with the watershed from now on deserves a site walk.
Definitely.
And also I would like somehow to get our bylaw fixed, and in the bylaw, just give me a second if I can. I had it out once upon a time. Give me a break. No. Oh, crap. I think I did not bring the file with me. I did not. I'm trying to remember. It did say in there to use something with the
a permeable surface or something like that to be.
No, I'm thinking what the terminology. What does the watershed protection section B say? And
Siltation and erosion control, or
no, it's all about this approximate Muschopauge watershed thing, and to use a link or something like that to pull up that line. We need to get that fixed. We need to make sure.
Oh, actually have the GIS locations of it to know exactly where it is instead of approximate.
We need to eliminate proximate out of that thing and have the exact measurements. And or have the bylaw fixed and have engineering plan show where the peak is of the rise from the reservoir and the 50-foot.
Would the watershed, would they have that documentation?
It would seem to me it should be somewhere.
Somebody would have had to done an engineering plan on that.
To me, I wish the heck I had my zoning book with me. But
I'll get a file up here.
I just think if we got that, we could add it to our, you call it Rutland map. I mean, we've got other stuff in there with wetlands, water, and all that stuff. So why shouldn't we add that to the town map?
I think it was was it a 30-something? It was either 28 or 30-something page for the wetland.
Page 32.
I just like the mask.
Okay, so
Right
watershed
there.
protection district,
And go to B.
B, the definition.
And right there, just before the end, it says, United States Department of Interior Geologic Survey of the Wachusett Quadrangle, AMS 6668.
All in within 50
4
feet.
Northwest Series V814, and all land within 50 feet thereof. And it's strange because I asked Anita about that, if this thing bylaw has been changed at all, because it was Harry Johnson that told me originally about from the reservoir up and 50 feet over.
Mm-hmm.
And then I hate to say this, but I will. It originated when Clee Jr. built his house up in the back of the state property there on the field.
Oh yeah.
He wanted it very close to the edge, and that's when they said it. Oh, we better have a way to keep that away from the watershed. And that's when it came up.
Okay.
So that's where that line supposedly came from. And I don't know whatever happened to the WPI, that they hired at the time. So anyways, that's where we're at. And to me, it's something that we need to fix. And another thing, I have not talked to him. I was hoping to run into him sometime. There's a gentleman that owns a piece of property on Wheeler Road. He's doing some logging. Now I see, some logging has been done in there. And I'm hoping he's not planning on developing or having, sell it for a house lot or something like that. And because anything on that side is non-buildable.
Mm-hmm.
But where is that defined that we would see that? Is it on any Rutland town plans?
Well, it's supposedly on a zoning map somewhat, that it shows the water district, the Muschopauge watershed district.
Okay. I just was trying to, if we could take that interior geological survey, there's got to be a map associated with that and have that overlaid on our Rutland map. That would solve a lot of problems, because that get rid of the approximate.
Yeah.
That would be the actual.
And like this house here, you can see that it just drops off in the back, period.
And if he has, he has this drawn, he just created, that's taken all the drainage around the entire house foundation.
Yep. Discharging it in the back.
Yeah. And that's 2 houses at least. The third one goes out front. I don't know what lot 1 does. All right. That's my 2 cents worth. Norm, who did we have? Who did our update of the maps? At Scaling? No, I'm a pronunciation name.
Used to work for Central Mass Regional Planning, and he's a town planner for.
Yeah, it was Bill Scanlon.
Scanlon, thank you. Yeah.
I think he had work or something like that out that neck of woods.
And I don't know. Yeah, the actual map maker.
He had a fellow with him.
Yeah.
Yeah.
And his name is on the maps. Both of them.
I mean, I'm not saying we just do it for this one, but if we have a business meeting and come up with some things that need to be addendum, we could pull those all together and make it as a one-stop shop to get 2 or 3, 4 items done.
Thing is, that map now is quite a few years old. I don't even know if whoever I should know the name, because I think his last name was Morin.
Land?
But whether he's even still doing that kind of stuff, whether he's still local, he may be in Australia by now. Who knows? But I guess one of the first things is you need to go and look up this thing.
Yes.
to see if there is a map associated with it. And for that matter, okay, when was this written?
It was, what did I say that Anita
79?
said? 79? Yes, May of 79 it was voted
So
to amend.
40 years ago?
Yeah.
They didn't have AutoCAD back then, I can tell you that.
Yeah, you know, that's
It was a
one
drafting.
thing. And even,
They didn't have
I don't know, I just keep thinking about not too long ago, looking up some of the, like floodplain maps and that sort of thing.
Yeah.
That were developed a long time ago. Boy, they're not very helpful.
No.
So,
gotta call it Trump.
you know, the first thing is, you know, seeing can you get good information, good data in order to actually draw a map.
The question is, if that map's in like a GIS format, you could always import that into an AutoCAD drawing if you had to.
Yeah.
But there's a question if.
That's the big if.
Mr. Chair, if I may, I'm going to share one of the ugliest images I have ever seen.
You're going to show me a drafting from the 70s, aren't you? Yep, I knew it. That's
That's
I can
in the
tell you what that
40s.
paper is because I know that paper well.
Yeah, let me just share this for Marilyn and anyone else who's still around.
Mm-hmm. Thank you.
Just a second. It's taking me a minute to work my computer correctly. That's the one. I'm going to steal your sharing again, Dave.
That's fine. I think we're pretty much done for the information I need up here, so we're gonna kill it out.
That's the one. So yes, this is,
That's drafting paper.
yeah, that is drafting. It's a scan of drafting paper, and it's blue tinted on my monitor.
So that is blueprints.
Yes.
Yeah.
And by the way, now I didn't find the exact map that they're talking about because this is Shrewsbury quadrangle, not the Wachusett quadrangle, so I'm a smidge south. But this is just a fast search what I could find with the coordinates given in the
Wow.
in the
But
bylaw.
it'll be of the same vintage.
Yeah, I'm sure.
Yeah.
There is a different one with that I found that's actually much more modern and but it's superficial materials. It's not watershed related.
Wow.
Okay.
So it might be difficult to get good, useful information out of it. That's my entire point.
Yes.
Because that was done with survey tools, not GPS coordinates. Not saying that they weren't accurate, but there is a.
Well, I mean, what was showed up on this plan here is way off base. I mean, that line almost has to go out to the front of the house, you might say.
Oh, it's that bad?
Well, it would have to go here, then 50 feet would have brought the house out here to the road almost.
Okay.
So
I believe this is from 78.
78.
Open file 78-951.
Wow. Yeah.
Suggests that's a year to me anyway.
That's how things, yeah. Okay. Same vintage. Well, I know what Riley was doing in 78, and it was all blueprints from the boards.
Well, how do we proceed from this to?
Oh, that's one.
I think the easiest way is to change the bylaw itself rather than get somebody out there, an engineer, to go and mark it. It should be the people that are involved that want to put a house in or something like that to show the proper.
Would that be, Norm, part of the title search?
Okay, I'm just a little curious as to how you want to change the bylaw.
To show an engineered plan of where the peak of the ridge, the watershed ridge is. And then to, site visit to verify or whatever. And And
That'd
then
only be in the subdivision, Dick? Wouldn't be in ANRs, right?
in the ANRs, any piece of property
Okay.
in the watershed district. Other than that, you know, how you're gonna hire somebody to go out there and physically, you know, map it.
I don't know how it gets triggered, but this is squarely in DCR territory in terms of demarking the watershed. So again, I don't know how it gets triggered, but they would have to be involved. They have a review process for anything that's in the watershed.
Well, they missed this one.
Well, it could be they were never involved, which was probably a failure of the process. For that.
Correct, yeah.
It was MDC back then also, DCR too. Well, all right,
Well, the only thing, Dick, you could modify the bylaw is something to the effect of, if based upon the map, if it was potentially in a watershed, then you have to go through the DCR process. You just have to know what that is. That's the only thing, or reference some legal section of the DCR that involves that process.
It's the Watershed Protection Act.
Okay.
And regulations promulgated thereunder.
Yeah. We could put that in there that would force it. I don't know. I'm just thinking out.
now I'm looking over there, I'm saying to myself, oh my gosh, there's a landowner on the watershed right there that's on the screen.
Oh, Ramey?
Yeah, Ramey Erickson
Yeah.
is on there. And, yeah.
Okay.
So, like I say, I don't want to, set precedents with that. And I feel, that it's probably better off that either let it go or let the town make a decision on what to do. It should probably be mentioned to the sewer water commissioners.
Board of Public Works.
Them too. So.
We don't have water sewer commissioners.
Oh, that's right. They dissolved that, didn't they?
Yeah, when the town accepted the Board of Public Works.
Yeah. No.
Yes.
How long ago was that?
1975.
Well, how come they keep calling themselves water and sewer?
And I correct them every time they say it.
Okay.
So do we need to send a letter to the Board of Public Works?
I would say because of the water treatment plant and all that, they should, have.
You just want to wind me up, don't you?
Well, I mean, to me, for crying out loud, they should be involved in this because it's their watershed. I mean, what goes behind these houses, and thank God it's an E1 system, so there's no sewerage or anything else like that in the back. So. All right. I'll talk to Joe anyways about this and let him know.
Okay.
And what I may do is take a ride out and talk to Dan out to Shaft 8 and have a discussion with him, and maybe he can either
see if he's got some wording or something that he's run into in other towns that we can use.
Yeah.
Copying is not above my skill set.
Oh, no.
Of course, I mean, that's Ware River, and we're on Wachusett side over here. So, and I don't know where John Scanlon is in this anymore. I think he moved up in the ranks now.
Yeah.
He used to be head of Wachusett, and he's now, I think he's in Boston now.
Oh, yeah.
He moved out of town too. So, yeah. All right. That's it. That's my 2 cents.
Okay, our last item.
I just wanted to say I think that's a really good catch, Dick. So
Thank you. All right. Now, if I can only get back to the Board of Assessors, I love catching all the mistakes they make on those maps all the time.
Oh, well.
My gosh.
Yeah.
I love it.
Last item on the agenda, update multi-board commission joint meeting on the Chapter 61A program. Follow up from the joint meeting and the letter to the select board relative to 61 process. Any thoughts, comments, complaints?
A lot of complaints. I think that probably, I'm hoping in the very near future, when we can gather together in one room, that we should have a joint meeting about this or anything else. I believe that's one of the things I hear a lot of is the lack of communication in this town. And I just feel that the night we had the meeting in that select board's office in there, that was a good one. And I think it's something that should happen once or twice a year when all the boards get together.
Oh, it's definitely not a bad idea. Unfortunately, right about now.
That'd be a big, huge auditorium.
Yes, it would. Yes, it would.
But I'm hoping that the things are going to straighten out here in the very near future. They got to.
I don't know. It's just, well, obviously, you know, just all kinds of stuff is just,
yeah.
It's among other things. A lot of stuff has just kind of gone by the wayside. You know, I just keep thinking about, you know, there was for what, almost a year, all this talk about our town facilities, meeting rooms, meeting space, and all that kind of stuff. And guess what?
Nothing happened.
Absolutely nothing. Not even a word about any of it now.
And then I have the question: if we're tearing down that building that we call home someday, why are we spending the money to put concrete and rebuild the thing?
Oh.
I didn't get that because I got the impression that was coming down sooner or later, like within the next 18 months.
Which building was that?
The
annex?
The annex, yeah, because it was either going to be repurposed or did something with
Repurposed.
repurposed.
It was to be the notion. I wouldn't call it a plan.
Okay.
The notion was to repurpose for dispatch to take it over because they needed more space than with the towns and all of that. But who knows?
Yeah.
But that was dependent upon being able to redo the lower layer of Community Hall,
right?
Which couldn't happen.
So it's a domino effect.
Yeah, well, it's many. Yes.
Okay, good enough. I just wonder what was going on with that because it was such an important thing to be done.
Yeah.
Okay.
Anyway, it's just died.
Yeah. So again, I guess Norm, I'll ask, and again, I will look at Peter's last portion of the town meeting, but again, I only have hearsay what my wife told me, that we were basically like, yeah, okay, well, we won't do it again. That's not our point. The point is you violate the law.
Yeah, well.
And we're just trying to be, is like I said in the past, we're giving you a mulligan on this one, but we don't want this to happen again. So I didn't take this lightly. So anyhow, maybe I'm just being too sensitive.
Oh, no, I'm sorry.
All right.
Son of a gun. Yeah, it's almost 10 o'clock for crying out loud.
Yeah, I'll show
you had asked about a list of different things, you know, that we should be working on.
Yeah.
And I thought I brought it with me, and I did not.
Okay.
And but just as well. So I think for the time being, Dave will be happy he doesn't have any extra work to do.
Yeah, and he can get home. Let's get this thing, let's sign and get out of here. Motion to adjourn.
Second.
Do I have any discussion?
Marilyn, don't forget, you're gonna have to come sign some paperwork.
Okay, are you gonna be around tomorrow?
Yeah, I'll be in the office pretty much the entire day except for lunch.
Okay. Will it be ready then?
It's the plans to be signed.
They'll be ready.
Yes.
Okay.
Okay.
Dick Williams, aye.
Tim Norwald, aye. John Moore, aye.
Yeah.
Marilyn,
Marilyn, aye.
aye.
Norm, aye.
And Tamika, aye.